Miss Grace? I can't hear you. I need to,
I'm sorry.
yeah, I was trying to let you know, to let the judge know that, I'm gonna be late logging on, here at ACDC.
Okay, we'll do.
This computer gonna be on, but for the, um, for the, for the inmates, position 9 and 10, 11, 26, and 29, I'm gonna be late logging in with them because I have, uh, two 9:30 courts that I need to get done.
Okay, we will inform the judge. Thank you.
All right, so as soon as I finish with those two calendars, I will have the ladies before her.
Okay, and that's 9, 10, 11, 26, and 29.
Yes,
Okay, thank you.
thank you.
Mr. Dotus, can you hear me?
Yes, morning.
Hey, good morning. Can you do me a favor? Do you have an announcement for Clarence Dennis?
Clarence Dennis, let's see.
Let's see, I believe.
That's the one that was incarcerated that you sent me.
That's a hold for announcement.
Okay,
I think, Mr. Walker, did you get the proof of incarceration?
Yeah, we're good. I got it.
Okay, perfect. Okay, I'll get with Mr. Dennis. He'll be on Zoom, so I need to speak with him on what he wants to do.
okay, all right. When you find out, let me know so I know what to do with his info.
Will do, Ms. Tyson. Thank you.
Thank you.
Actually, I just got it to work. Yes, ma'am.
Morning, everyone.
Good morning.
Good morning.
Good morning.
Judge.
Do I, Ms. Grace, do I have, the other email with the list?
Yes, I emailed it to you. Yes, ma'am.
Okay, let's see.
Announcements.
Right. That's the one, let's see. Hold on, but I'm looking for, oh, okay, I see it. Hold on a second, let me just print real quick. Excuse me. All right, deputies, good morning. I am Judge Regina Mincy, and we're going to begin our state all-purpose calendar, SAP, and other ancillary calendars that we have this morning. I want to first state that I want to first state that this proceeding is being recorded and live streamed on YouTube, so govern yourselves accordingly. Listen to your attorneys and do not make any statements that may be against your interests at this point. I want to remind the defendants on the calendar that you do have a right to remain silent, and you do have a right to representation. We will go ahead and get started, and deputies tell me who we have first.
Hey, Lloyd, I'm on the. I can't get this stupid speaker system.
Good morning, y'all.
Good morning.
Can we go to probation revocation calendar first?
And we do what now?
The probation revocation calendar?
Oh, you want to do probation first?
Yes.
Okay.
To, position 3 and 4, Ms. Latoya Bryant, she's in front of you now.
All right. All right, so we have, you said position 2.
No, position 3 and position 4, Ms.
Oh,
Latoya.
3 and 4.
Yes.
Let me turn my volume up a little bit. All right, this is Latoya Bryant. Case number 17 CR 006035D. And position 4, 17 CR 009398D. Charged with DUI, driving on a suspended license and other cases. January the 14th, 2017 and July 2nd, 2016. Probation?
Yes, Your Honor. I'm sorry.
Right,
I've been dispersing.
disposition on position rather 3. And what do you have? With
My
Latoya Bryant?
apologies. I don't have anything for her. My apologies. I don't have anything for position 3 or 4 at all. I'm sorry. Can you give me just one moment?
Okay,
Your Honor,
yes.
yesterday or the day before, we received a memo from probation indicating that these 2 positions would be recommended for referral to DUI court. She started DUI court. There were interruptions due to health, and therefore probation has analyzed the situation and has decided to put her back into the DUI court. She remembers that Judge Edline and Judge Taylor do the DUI court. So I've gotten her contact information on a sheet to send to JCS with her address and phone number. And she knows the address of 132 Mitchell Street, second floor, to report to as soon as she's out.
All right. Do I need any history from pretrial or not? Sounds like I don't. If she's going back into DUI court.
Right.
I would agree with him, Your Honor, and I just stepped in this morning last minute for a colleague, but she is DUI court and they do hear their own revocation hearings. So that's probably why I don't have paperwork for her this morning.
Correct. Ms. Grace, do you have any additional information at all?
No, ma'am.
Okay. All right, we will go ahead and refer it back to DUI court. I don't know what else to do at this point. Does she have a bond? Mr. McLean,
I do not have the booking sheet, Your Honor. I'm sorry.
can you look that up for me, Ms. Gray?
Okay, just one moment, I will.
Okay.
Your Honor, if in DUI court, if she's already done a plea, it wouldn't be a bond situation. It'd just be part of the sentence.
Oh, okay, that's true. I don't get many of those. So help me out there. I understand.
Yes, Judge, this is Ms. Grace. It just needs to go back to Judge Edline.
Okay. So positions 3 and 4, further notice and returning to the division judge. And I'll just put that down for both of those for DUI court. All right, anything else, Mr. McLean?
Nothing that I can think of in this case, Your Honor. Thank you.
All right, thank you.
Done.
Position 43, 44, and 45.
Hey, Duffy, hold on. We're doing probation court right now. Probation.
Oh, okay. It's gonna be.
All right, who do we have next?
Next, we're gonna go to position 7 and position 8 on probation, Mr. Raymond Johnson.
Okay. This is 22 CR 003121E. Raymond Johnson, charged with 1 count of battery, family violence, and criminal trespass from May 19, 2022. And then, of course, the probation violation from April 26, 2023. Probation?
Yes, Your Honor. For Mr. Johnson, we have that he has failed to pay probation fees. He's failed to pay towards the Georgia Victim Crime Fund. He failed to report as directed on July the 12th, July 15th, and April the 14th. He also failed to complete as directed the Domestic Violence Intervention Program. He also failed to pay restitution in the amount of $300. And he also failed to appear for a revocation hearing on April the 26th of 23 of this year.
All right, Mr. Dotis?
Yes, Your Honor. I spoke with Mr. Johnson yesterday and did receive probation's recommendation, which is a time served since it just has 21 days remaining. We would just ask this court to accept probation's recommendation.
How many days left to serve?
21 days according to Ms. Harris's email.
And state that again, kind of away looking at my printer. Go ahead, state again what you stated after that, after the 21 days.
Yes, 21 days remaining, and probation's recommendation is just for time served.
Okay. All right, I will go with the recommendation of time served. Mr. Johnson, got to get it together here. Else you're gonna be back in Fulton County Jail for a longer time. My inclination is not to, but I will go with the recommendation.
Recording in progress.
All right. So get signed up and get back on track.
Thank you, Your Honor.
Thank you.
Next, Your Honor, we're gonna go to position 1 and 2 on the probation calendar, Mr. Walter Avery.
It's still about 150.
Okay, this is Walter Avery Jr., 21 CR 000098Y. Charge of 1 count of theft by taking from 10/31/2020. And then the probation case 23 PV 000781 5/25/23 probation.
Yes, Your Honor. He owes probation fees, supervision fees in a total of $280. Victim crime fund in a total of $63. He failed to report on January 19th, 2023, February 21st, 2023, and March 6th of 2023. He owes restitution amount in a total of $235.03. He failed to complete 40 hours of community service. He failed to complete a shoplifting course, and he failed to appear for a private revocation hearing on May 24th of 2023. He has 4 months, 12 days left on probation. We are recommending for time served.
Okay. All right, I will go with that recommendation for time served. However, I'm not excited to hear about this, Mr. Avery. So let's get back on track, get it together so that you don't end up back down here. All right, I will go with the recommendation. Anything else?
Nothing else, Your Honor. Thank you.
All right.
Next, Your Honor, we're gonna go back to the SAP calendar, and we're gonna go with position 14 and 15, Miss Charlotte Grant.
Okay.
And Your Honor, this is going to be a negotiated plea for position 14. And the 15 should be a no for us.
All right. All right, this is 23 CR 000623D. Charlotte Grant, charged with 1 count of DUI under the influence of alcohol as safe, speeding, failure to maintain lane or improper lane change, failure to yield right of way to emergency vehicle, and willful obstruction of a law enforcement officer with the offense date of October the 26th, 2020. And then, of course, position 15, 23 FTA 000612 from 5/15/2023. State.
Yes, Judge, in this matter, the state's recommendation for position 14 is 12 months to serve, 34 days, credit for time served, 17 days, balance probated, alcohol, drug evaluation and treatment, a risk reduction course, $300 fine, 40 hours community service, and a victim impact panel. And judge, position 15 would be null prost if the plea goes through on position 14.
Okay. All right, Mr. Dotis, is that your understanding?
Yes, Your Honor, that's our understanding, and we do stipulate to the factual basis, venue, and ID for the purpose of this plea.
All right. And so, are we ready for the negotiated plea?
Defense is ready, Your Honor.
All right. And so, Ms. Grant, can you raise your right hand for me so I can swear you in? Do you affirm that the testimony that you're about to receive, testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right, you can put your hand down. I'm going to ask you a series of questions in order to accept your guilty plea, okay? And to make sure that you understand what you're doing here today, all right?
Ma'am.
Okay, and at the present, are you under the influence of any medication, drugs, or alcohol?
No.
Are you satisfied with the services and representation of your attorney?
Yes.
Do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes.
Do you understand that you're giving up and waiving the right to remain silent and not testify against yourself?
Yes.
Do you understand that you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes.
And you're prepared to waive these rights today, is that correct?
Yes, ma'am.
Has anyone told you that you'll receive a lesser sentence for pleading guilty?
No.
Has anyone promised you anything to plead guilty?
No.
And do you understand that if you're on probation, your probation may be revoked or affected because of this guilty plea today?
Yes.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes.
And so you heard the conditions and you understand what you must do. You have a lot of things that you have to take and do. You understand that?
Yes, ma'am.
All right. And so if you have no questions, I will accept your guilty plea. And I wish you good luck in completing all those conditions.
Thank you.
And Your Honor, we would request that Ms. Grant, some of Ms. Grant's probation fees be waived to help her get back on her feet, and if she could switch to non-reporting status upon completion of all conditions.
If the state has no objection, I would allow her to go to non-reporting after she completes the conditions.
We have no
I'm-
objection to that, Your Honor.
Okay, I'm not going to waive any of her fees at this time.
Understood, Your Honor.
Uh-huh.
And all of the charges will run, the rest of the remaining charges will run concurrent with A.
I'm assuming so. Is that correct?
Judge, I apologize. I couldn't hear that.
Say that again, Ms. Grace.
The remaining charges will run concurrent with driving under the influence of alcohol.
That's correct, Ms. Grace.
Thank you.
All right. There's nothing else. The case is concluded and the plea has been accepted. All right.
Next, Your Honor, we're gonna go to position 23, position 24, and position 25, Mr. Torneo Jackson.
All right.
Good morning, Judge.
Good morning.
Judge, is that Taranio Jackson?
Yes, Ronnie Jackson.
Judge, that is my client. I haven't had a chance to talk to the state about it. If we could go to a breakout room when you get a moment.
All right. Who needs to be in that breakout?
That's my case, Your Honor.
Okay. But then you're on the other cases, is correct? Are we having to wait to the end, trying to logistically see who's the other prosecutor?
The other prosecutor is Mr. Walker, Judge. I can tell you my cases are positions 1 through 25. So we could either run through all of mine and then I can meet with Mr. Dennis, or we could move
That's
further
fine.
down the calendar.
that's fine. I'll just wait till you're concluded your other matters.
Well, I'll push him to the back, Your Honor.
Okay. And actually it's Mr. I always tease Mr. Dennis Murphy, isn't it Mr. Murphy?
That's correct.
Murphy. He doesn't know how to put his last name on there, so we mess
Oh,
with him.
yeah.
That's why it says Dennis.
Right.
Good morning, Mr. Walker. How are
Good
you?
morning. I'm good. Good morning, Your Honor.
Good. So you have the end of the calendar?
Yes, ma'am.
Okay, good. All right. Well, we'll hold on that case. And is it Pilon?
Judge, it's actually Pelon.
Pilon. Okay. Okay.
Yes, ma'am.
Thank you.
Your Honor, we can go to medical.
Okay.
Position number 38, Stewart.
Okay.
Yes, Judge, I actually still need to speak to Mr. Stewart. If I could have a moment to do that.
Who's talking?
Sorry, Public Defender Finley, apologize.
Oh, okay. I see you there, Mr.
Morning.
Finley.
Morning, Judge.
Good morning. Haven't seen you in a little while.
But yeah, if I could just have a brief moment just to speak to Mr. Stewart.
All right.
Well, I don't have a phone up here, so
Uh-oh.
when you speak to him is through a breakout. You don't have to talk in open court.
Okay, I can do that.
All right. And Mr. Finley, do you have any other cases today?
Yes, I do. I have positions 37 through 48.
Okay. Is that the only one you need to speak with?
I just need to speak to him and then the probation revocation, I believe is on 4 with Preston White.
Yeah, I sent a message to 4 North.
Okay, if you think it's gonna be short, we can do it, or we'll try to keep moving. Deputy, what's easiest for you all down there?
I can go to the top of the calendar. I can go to position number 1, Mr. Marcus Booker.
Okay,
The only other one I had was also number 46. I don't know what they are. I couldn't find them yesterday.
Who's that?
They're very unions. Here's a conflict.
I believe he's Miss McLeod's client, Your Honor. I don't know if she's on.
let's see. Do you see her, Miss Grace? I don't think I see Miss McLeod yet.
Okay.
Sure, she's coming. She may be in another courtroom.
We can go to position 43, 44, and 45.
He's in a breakout right now, Duffy.
Who?
Zach.
Okay.
Can you check your chat and see if you can find those defendants on 4 North? And Your Honor, we can go to position 4 and 5. Mr. Trayvon Crane.
Okay.
Y'all switch out.
4 and 5.
All right, this is 22 CR 007040J, Trevon Crane, charged with 1 count of criminal trespass and fare evasion. Second case is a FTA case from January 5th, 2023. State, what do we have?
Judge, for position 4, our recommendation is a time served sentence and stay away from MARTA locations. And position 5 will be a no cross if the plea is completed.
And let's stay away from all MARTA.
Yes, Judge.
Okay. Does he already have a ban or prior times? Will this be forever, or is it till 2 years from now, next year?
I am not positive on that, Judge. I defer to Mr. Walker. I know he had an active MARTA ban at the time of the criminal trespass. That's the reason for the criminal trespass. I don't know if MARTA has instituted its own subsequent to this matter.
Because usually I'll say, sometimes it's some years, sometimes, I don't know if it's forever. Mr. Walker, do you have any info? Is this a complete total ban forever?
I do not have any additional information, but we could just put remain compliant.
Mm-hmm.
Yeah, Your Honor, with MARTA, we usually request just comply with all active MARTA suspensions so that once those suspensions run, Mr. Crane is able to navigate the city.
Right. I didn't want to use the strong, harsh word of ban and forever. And we'll say that he is to stay away from all MARTA and comply with any and all suspensions if and when they expire, some language similar to that.
We'd be agreeable to that, Judge.
Okay. All right. Okay. And so that's your understanding, Mr. Dotis?
That's our understanding. We do stipulate the factual basis, venue, and ID.
Okay. And so we're ready to take the plea. Mr. Crane, can you rate? Oh, state, you told me credit for time served. Gotcha. I was getting ready to
Yes,
say, what
Judge.
are the other? No probation, no other terms.
That's
All right.
correct, Judge.
Good. Mr. Crane, are you ready to take your plea, sir?
Yes, ma'am.
All right, raise your right hand for me. There's Mr. Crane. And you are Mr. Trayvon Crane.
Your Honor, Mr.
Okay.
Crane is sitting next to me.
Mr. Crane is in courtroom 2, Your Honor, not 4 North.
Oh, I'm sorry. Okay, I was focused there and then they switched with me. I apologize. So Mr. Dotis, you are sitting next to your client. Okay. Thank you, Mr. Crane. Raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, Your Honor.
Okay, put your hand down for me. I'm going to ask you a series of questions to make sure that you understand what you're doing and that your plea is voluntary today, okay?
Yes, Your Honor.
All right, are you presently on the influence of any medication, drugs, or alcohol?
No, ma'am.
All right, are you satisfied with the services and representation of your attorney?
Yes, ma'am.
And do you understand that by pleading guilty, you're giving up or waiving the right to the presumption of innocence?
Yes, ma'am.
That you're giving up or waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
And that you're giving up or waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
And are you prepared and agree to waive these rights today?
Yes, ma'am.
Has anyone told you that you would receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone promised you anything to plead guilty?
No, ma'am.
And you understand that if you're on probation, your probation could be affected by this guilty plea here today?
Yes, ma'am.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes, ma'am.
And so as to the charges of criminal trespass and fair evasion, how do you plead?
Guilty.
All right, and you understand that you're getting credit for time served and you are to stay away from all MARTA and comply with all suspensions
Yes, ma'am.
and not use MARTA until those suspensions are up.
Yes, ma'am.
Are we clear?
Yes, Your Honor.
Okay. All right, good luck to you and I will accept your guilty plea.
Thank you.
All right.
Position 36.
Okay.
Thank you.
All right, position 36 is Anthony Polk, 23 CR 004356F, charged with 1 count of lauder and prowling from July the 10th, 2023. What do we have here?
Negotiated plea, Your Honor, for time served.
All right. And that is correct, Mr. Walker?
Yes, Your Honor. The state's recommendation is going to be a time served offer of 18 days, balance suspended, with the conditions of a stay away from Georgia Tech's campus.
All right. And that's your understanding,
Fine. Yes, Your Honor,
Mr. McLean, okay?
that is our understanding of the terms offered. He does wish the court to accept his negotiated plea while accepting his terms. He does stipulate to the three necessary elements.
All right. And Mr. Polk, you're ready to take a plea, sir?
Well, no, if you have to unmute. It might be frozen, Your Honor.
Oh, yeah, because he's not even moving, huh?
Nope.
There they go. All right. Mr. Polk?
Yes, ma'am.
Okay, can you hear me now? I
Yes,
think.
ma'am.
All right, you're ready to take a plea today?
Yes, ma'am, I am.
All right, I'm going to ask you a series of questions to make sure that you understand what you're doing today and that your plea is voluntary. Can you raise your right hand for me?
Yes, ma'am.
Do you affirm that your testimony that you're about to give is going to be the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, you can put your hand down. Are you presently under the influence of any medication, drugs, or alcohol?
No, ma'am.
Are you satisfied with the services and representation of your attorney?
Yes, sir. Yes, ma'am.
And do you understand that by pleading guilty, you're giving up or waiving the right to the presumption of innocence?
Yes, ma'am.
And that you're giving up or waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
And that, excuse me, that you are also giving up the right to remain silent and not testify against yourself?
Yes, ma'am.
And are you prepared and agree to waive these rights today?
Yes, ma'am.
Has anyone told you to receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone promised you anything to plead guilty?
No, ma'am.
And do you understand that if you're currently on probation, your probation may be revoked because of your guilty plea today?
Yes, ma'am.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes, ma'am.
All right, and as to the charge of loitering and prowling, how do you plead?
Guilty.
All right, and so again, you just need to stay away from the Georgia Tech campus so you don't come back down to the Fulton County Jail. Can you do that for me?
Yes, ma'am.
All right, good. All right, good luck to you. I will accept your guilty plea.
And that's time served, correct?
Ready for time served. Yes, they will start processing you.
All right, thank you, ma'am.
All right, you're welcome.
Position 37.
All right.
Perception says like an attorney trying to get in.
All right, this is 23 CR 004399F, Ronnie Savoy, charged with 1 count of criminal trespass and damage to property and a 2nd count of battery. What
Your
do we
Honor.
have state? Yes,
My apologies. Is this position 37?
yes, should be
Okay.
Ronnie Savoy.
Thank you. Yeah, I believe this was Attorney Finley's case
Oh, and he's in the breakout.
in the breakout room. I'm not sure what the status of that case is.
Okay, we'll have to come back to it.
Josh. Probation. Position 27. I hope he's not feeling it.
Hey, what's up? Hey, is this Preston?
Oh, Mr. Finley?
Oh, sorry.
No, well, you want us to come back to yours? We just
Oh,
moved
sorry.
him out of the chair.
Okay, yeah, no, I did. So I did speak to Mr. Bennett, and I think I can go ahead and handle him. I just had to talk to, I think, one more person in 4 North. But I can go ahead and proceed.
You want to do this one first? Okay.
Yeah, definitely.
This is, I cannot pronounce his last name. Someone help me.
Konechny.
Konechny? Okay, and I apologize if I'm tearing it up a little bit. I'm not doing.
Judge, this is not, I will say this is not mine. He's
Oh.
not doing it though.
Who do you have, Finley?
I have a 37 through 48.
Okay, I have them. Are you ready to? Do you need to talk to them or are they ready?
I think the only person I have to talk to at 4 North is Mr. Preston White from the probation calendar.
All right, and so, Mr. Joshua Kineski, who is he represented by?
Is that Attorney McLean, position
McLean?
27? All right. Mr. McLean, do you have position 27?
I do. That's the one that's hard to pronounce.
Yes,
Next name?
I think it's Konetsky, something close to that, and I apologize
Right.
for not getting it correct.
The last part's gonna have that NY sound, so it'll end up in a neat sound.
Gotcha. And it's one count of theft by taking.
Correct, Your Honor. It is.
What do we have, Mr. Walker?
Yes, the state's recommendation is going to be 12 months to serve, 38 days, credit for time served, 19 days, balance probated, with the conditions of an anti-theft course and a stay away from the instant location, which is a recycling center. It's called Keep North Fulton Beautiful, is located at 470 Morgan Falls Road in Sandy Springs, Georgia.
Right. Is that your understanding, Mr. McLean?
That is correct, Your Honor. What we're dealing with here is simply dumpster diving, and there was a computer in there and somebody felt like it had work and shouldn't have been dumpster dived for. That's what my understanding is. The states may be different, but he's ready to go forward.
Okay, all right. Mr. Konetsky, you ready to take your plea today?
Yes.
Yes, and will you stipulate for me, Mr. McLean?
Yes, Your Honor, we do stipulate factual basis, venue, and identification.
All right, raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, put your hand down for me. Are you presently under the influence of any drugs or alcohol or medication?
No, ma'am.
Are you satisfied with the services and representation of your attorney?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up or waiving your right to the presumption of innocence?
Yes.
That you're giving up and waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
That you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
And you're prepared and agree to waive these rights today, is that correct?
Yes, ma'am.
And has anyone told you that you receive a lesser sentence for pleading guilty?
No, ma'am.
And has anyone promised you anything to plead guilty?
No, ma'am.
And do you understand that if you're currently on probation, your probation could be affected by this guilty plea today?
Yes, ma'am, but no probation at the moment.
Okay, good. And do you offer this guilty plea freely and voluntarily with the full understanding of the charge that's brought against you?
Yes, ma'am.
All right. And so as to the charge of theft by taking, how do you plead?
Guilty.
All right. I will accept that guilty plea, and what you have to do is take that anti-theft course and to stay away from the recycling location. Keep North Fulton beautiful. Can you do that?
I sure can, yes.
Okay, great. All right, good luck to you, and I will accept your plea.
Okay, thank you. Now, is that time served on the FTA?
Yes, it is. The FTA is going to be dismissed, and then time served on the underlying charge, which is the theft by taking, and the others dismissed.
Okay, thank you very much.
All right.
Position 43, 44, and 45. Mr. White.
This is Mr. White. All right, I have case number 22 CR 002791F, one count of simple battery family violence. Second case 23 CR 004403F, second count of battery family violence. And then I have the third case is the FTA case from February the 1st, 2023. State.
I believe these are arraignments, correct or no?
Oh.
Yeah, so that's correct, Mr. Walker. So I just wanted to verify actually what his bonds were on both. Most importantly, I just want to make sure if he still has a signature bond on position 43.
Miss-
Okay, I will
Okay,
have to check Odyssey to see.
Okay. Most likely I just wanted to, yeah, see if that's still a signature bond. Most likely, we're not gonna need to address bond as he's actually being held on some other
something
charges.
else. Okay,
Yeah.
Oh, 1 second, let me check the jail screen.
okay.
Let me make sure you check. So I'm showing that he's being held on felonies.
Yeah, no, that is correct. I just wanted to make sure, I guess, that signature bond was still in place or if that got revoked for position 43.
I do not believe he's being held on 43. He is being held on 44 because he FTA'd on that one.
Yeah, I believe that one's a 3,000 surety bond, correct?
2,000.
Okay.
And then I'm showing a lot of felonies with.
Yeah. So, yes, Judge, so this would just be an arraignment as he is being held on some other charges. So I just wanted to make sure
Okay,
bonds didn't go up a lot.
so we're arraigning him on both on just 44 or
That's correct.
43? Okay,
I think we ran
43.
him on both, don't we, or no?
Are
Or
we
is it both?
arraigning him
Yeah,
on
if-
both?
We could do on both, yeah, that's fine.
Okay, all right. So Mr. White, Calvin White.
Yes.
Okay, I was making sure that was you. Again, on this first case of simple battery family violence from March the 25th, 2021, we're going to formally arraign you on this case. And Mr. Finling, do you waive formal reading of the accusation?
I do so stipulate.
Okay, and stipulate, okay. And so again, Mr. White, you're being charged actually in two cases, one ending in 403F and one ending in 2791F. Both are one's battery family violence from March the 4th, 2023, and the other is simple battery family violence from March 25th, 2021. Are you aware of both of those cases?
Yes.
Okay, and so what I'm letting you know again is that you're being formally charged in both cases by the Solicitor General's office in Fulton County. You've been charged with both of those. I've mentioned the offense dates, and each case carries a maximum sentence of up to 1 year in jail or a maximum fine of up to $1,000 for each charge. Your case is going to be reset for a jury trial. That trial will be scheduled by the state court division judge whom the case is assigned to, and the case will be further noticed for trial. And at the jury trial, you'll have a right to an attorney, which you have now. You do not have the burden to prove the charges at trial. The state will be represented by the Solicitor General, and they will bear that burden, and they will have to convince a jury beyond a reasonable doubt in order to get a conviction. I am going to ask you, how are you pleading to both of those cases? Guilty or not guilty?
For the first one, not guilty. The second.
No, Mr. White, so we were both agreed we were gonna plead. It was your wishes to plead not guilty on both. Okay? That's still what you want to do.
All right, and so you're pleading not guilty to both, is that correct?
Yes, ma'am.
Okay, all right, I will accept your not guilty plea, and you have been arraigned on both cases. They will be further noticed for trial.
Position 38, Stewart.
Okay.
And Judge, if I could, so I'm in another room at the jail, so I could talk in a breakout room. So I'm actually away from all of my notes right now. So if I can please speak in a breakout room to Mr. Preston White, who's in 4
Okay.
North, and then I can go back into the courtroom.
Okay.
I'm not sure if the gentleman could hear me at 4 North.
4 North, did you all hear that?
I believe he's.
Oh, yeah.
Yes,
Mr. Finley has an announcement.
yes, sir. Could I please speak to Mr. Preston White, who's at 4 North? Because I need to go back into the courtroom, and I'm just here so I can speak to Mr. Preston White. I'm away from all my notes and so on.
Phone is not available, so the only way we can do that is the breakout.
No, I understand. So could I be in a breakout room with Mr. Preston White, who I believe you have there?
Yes.
If I could do that now, if you don't mind.
Oh,
Your Honor, if you're ready, I have position number 18, Mr. Larry Harris, in courtroom 2.
Okay.
This is going to be a negotiated plea, Your Honor.
All right. This is case number 23 CR 004428E. Mr. Larry Harris, you're charged with 1 count of criminal trespass. State.
Judge, I apologize. I was looking at another case. Would you remind me the position number?
Yes, this is position 18, Larry Harris.
Thank you, Judge.
Uh-huh.
Judge State's recommendation on this is 12 months served 24 days. Credit for time served 12 days, balance suspended, and a stay away order from 3040 Lakewood Avenue.
All right. Is that your understanding, Mr. Dotis?
Yes, Your Honor, that's our understanding, and we do stipulate to the factual basis, venue, and ID. Mr. Harris is clear that the stay away location is a BP gas station, and he knows not to go back there.
So what type of gas station?
It's a BP.
BP, okay. All right, you're ready to take the plea, Mr. Harris. Are you ready to plead guilty today? Can you hear me, Mr. Harris?
yes, ma'am.
Are you ready to plead guilty today?
Yes.
All right, I've got to ask you a series of questions and swear you in before I can accept your guilty plea to make sure you understand what you're doing here today, okay?
All right.
Raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
I have to be able to hear you.
Yes.
Okay, all right. And you got to speak a little loud for me. And let me ask you, the first question is, are you under the present influence of any medication, drugs, or alcohol?
No.
Are you satisfied with the services and representation of your attorney?
Yes.
And do you understand that by pleading guilty, you're giving up or waiving the right to the presumption of innocence?
Yes.
And that you're giving up and waiving the right to remain silent and not testify against yourself?
Yes.
That you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes.
And are you prepared and agree to waive these rights today?
Yes.
Has anyone told you you will receive a lesser sentence for pleading guilty?
No.
Has anyone promised you anything to plead guilty?
No.
And do you understand that if you're currently on probation, your probation may be revoked or affected by this guilty plea today?
Yes.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes.
All right. And so as to the charge of criminal trespass, how do you plead?
Yes.
All right. And so you understand that you are to stay away from 3040 Lakewood Avenue, which is that BP gas station. Can you do that?
Yes.
All right. We shouldn't see you back here if you comply with those conditions. And I wish you good luck. I'll accept your guilty plea, okay?
Yeah, ma'am.
All right. Have a good one. Thank you.
Next, we got position 19 and position 20, Mr. Thomas Hutchins.
Okay. All right, I have 20 CR 004307F, Thomas Hutchins, charged with one count of battery family violence and a second count of hindering a person making an emergency telephone call from June 25th, 2020. I have a second case is the FTA from August the 10th, 2022. What do we have, State?
Yes, Judge, the state's recommendation on the first case, position 19, is 12 months to serve 48 days. Credit for time served, 24 days. Balance probated. Family Violence Intervention Panel, 40 hours of community service. No further contact with the victim, Tana Parrish. And a stay away order from 1776 Temple Avenue, College Park. And the second case will be null prost if the plea is completed.
All right. Is that your understanding, Mr. McLean?
Your Honor, it is our understanding. He asked the court to accept his negotiated plea.
And I believe, making sure you stated, Mr. Pilon, that was the FVIP, is that the 24-week program, or were you speaking of a victim impact panel?
Victim Impact Panel, Judge.
Oh, not FVIP.
No, I'm sorry. It is FVIP, Judge, the 24-week.
Oh, it is. Okay.
Yes, Judge.
Okay. Gotcha. Making sure of that. All right. That's your understanding, Mr. McLean.
It is, Your Honor.
All right. Mr. Hutchins, are you ready to take your plea this morning?
Yes, ma'am.
All right. Raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right. I need to ask you a series of questions. The first being, are you presently under the influence of any drugs, alcohol, or medication?
No, ma'am.
Are you satisfied with the services and representation of your attorney?
Yes, ma'am.
And do you understand that by pleading guilty, you're giving up or waiving the right to the presumption of innocence?
Yes, ma'am.
That you're giving up or waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
That you're giving up and waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
And you are prepared and agree to waive these rights today?
Yes, ma'am.
And has anyone told you that you will receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone promised you anything to plead guilty?
No, ma'am.
And you understand that if you're on probation, your probation could be affected by this guilty plea here today?
Yes, ma'am.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes, ma'am.
All right, so as to the charge of battery, family violence, and hindering a person, how do you plead?
Guilty.
All right, I will accept your guilty plea. And you understand that you got to do the program and you've got to start that and complete it, or else you have to start over. You have to go straight through with the FVIP. You got community service, no further contact with the victim, and a stay away from 1776 Temple Avenue in College Park. All right.
Thank you, Your Honor.
All right.
We can go back to Mr. Preston White.
Mr. White, okay. No, Mr. Preston, I'm sorry. Which one did you say, Deputy?
Preston White.
He's on probation 9 and 10, Your Honor.
Thank you.
You're welcome.
All right, I have 22 CR 006231J. Mr. Preston White charged with one count of theft by taking from 9/9/2022. And then the second case is the probation revocation from January the 25th, 2023. Did he have probation?
Yes, Mr. White owes probation supervision fees in a total of $120, victim crimes funds in a total of $27. He failed to report to probation on November 7th, 2022 and November 22nd, 2022, and he failed to complete a shoplifting course. Huston White has remaining 6 months, 30 days remaining on probation. Probation is just active for time served.
Okay. All right. Is that your understanding, Mr. Finley?
That is my understanding, Judge, and I did speak to Mr. White about where he fell short. I would ask you, Your Honor, to accept the probation's recommendation, which is for the time served, which I spoke to Mr. White about, and we have agreed.
All right, I will accept the probation's recommendation of credit for time served. All right.
Position 38, Stewart.
Okay, 38.
Oh, no, I didn't know this.
Say that position again, or
38.
which calendar is this, Ms. Grace?
He's on the primary SAP calendar. His full name is Ramon Stewart.
Okay.
And I'm gonna have to clarify some of the charges because I recognize there's still some felonies listed, but this was a felony transfer to our office.
Oh, okay.
Johnson. Avery had a button.
Ms. Grace, is this the one with 22 or 25? Because mine stops.
You know, there's on the calendar, there's 48.
No, I'm at pages.
Oh, pages. It
Because
is.
my page stops. One at
Oh, wow.
22.
I have 33 pages.
Okay, and then I have another one with 25. I have two, obviously, 22 and 25. Let me see. I may have to get you to call it because I don't have.
I can forward you the calendar that I have.
I have 25 pages too.
Yeah, me too.
And Mr. Stewart is on page, for me, is page 20
Yes.
in
yes.
position 38.
Okay, hold on. Let's see.
Savoy is on this.
Okay.
If it prints out the
Yeah.
same, Savoy is on the
I
same
have
page.
38 and not 48. So
Okay.
I don't know, Mr. Walker, but we'll get it together by the end of the calendar.
Yeah.
All right. So I have him here 23 CR 004525G. Is that correct?
Yes.
All right. And it's Ramon Stewart.
Yes.
And I won't read the charges to confuse us. So tell me what you have, State.
Okay, so he has 5 charges that are pending. The first count is battery. The second count is simple battery. The third count is cruelty to children. The fourth count is cruelty to children. And then the fifth count is simple battery.
Okay.
This was a felony transfer to our office, so there currently is not a bond set, and I believe defense is requesting a bond hearing.
Okay.
That's correct, Judge.
And I have the offense date for all is April 21st, 2023.
Yes.
Okay. Do we have pretrial on with the history, or will State give me the history?
Nope, I
There we go.
haven't.
Oh,
Yep, I
good morning.
haven't.
How are you?
Hey, good. How are you?
Good.
Looks like Mr. Stewart, he has 7 arrest cycles beginning in 2004. It appears the clarification of the charges on the calendar. So his last arrest was April 22nd, 2023. And it was for the 2 counts of aggravated assault and the cruelty to children. That's what's listed on the GCIC. Let's see. It appears he doesn't have any other felony convictions. Yep, no felony convictions. He did have a misdemeanor willful obstruction that he received first offender treatment on. That was March of 2008, and the case was sealed March of 2009 in Newton County. See, and he does have 2 arrest cycles out of Louisiana. His last arrest was October 2013 for disturbing the peace, public intoxication, and resisting an officer. No disposition is listed for that case, Your Honor. Nothing to add.
All right.
Hey, Your Honor, in this case, law enforcement was dispatched to 1974 County Line Road. They spoke to the victim, Ms. Hall, who advised that her boyfriend came home intoxicated. He accused her of cheating, at which point he became irate. He did grab Ms. Hall and throw her through a wall, and then he began to choke her. Ms. Hall's 4 children were present. She had a 14-year-old and a 13-year-old that attempted to intervene. Her oldest son, the 14-year-old, who I will refer to as A. Miller, attempted to separate Mr. Stewart off of his mother as Mr. Stewart was choking his mother. Mr. Stewart then punched the juvenile child, Mr. Miller, in the face, and then began to choke Mr. Miller. At that time, her other son and the victim, Ms. Hall, collectively was able to push Mr. Stewart out of the home. But then again, he grabbed her juvenile son, Mr. A. Miller, and body slammed him. Upon arrival, the law enforcement officer was able to observe the hole in the wall in the living room. There was blood on Mrs. Hall's shirt, and he did observe a ripped shirt on the juvenile, Mr. A. Miller. For the first count of battery, the state is requesting a $3,000 surety. For count 2, the simple battery, we're requesting a $2,000 surety. For counts 3 and 4, we're requesting a $1,500 surety. And for counts 5, which is another simple battery, we're requesting a $2,000 surety. If my math is correct, I believe that is a $10,000 good bond in total. Nothing further at this time.
All right. Mr. Finley?
Yes, Judge. Mr. Stewart is 38 years old. He does have 2 children. That being said, with his current girlfriend, she does have 8 kids, which he presumes and has, he supports, and he's the main financial supporter of them. He's been with his girlfriend. They've been friends for 15 years. But like I said, they've been together, living together, and he's been financially supporting her and her family as well. As we heard, Judge, he does not have any violent convictions. He does have community ties, Your Honor. He's been in Georgia for 33 years. He has friends, family here. And I've stressed to him the importance of returning to court. He assured me that he would. Also, the stay away is not going to be an issue, as he does have somewhere to stay. He'll be staying with his mom, Judge. And while I do recognize the seriousness of the charges, and I did hear the incident report, it is exactly that. It's an incident report, and he is presumed innocent on all of these charges, Judge. So I would ask for a bond to be set. Totaling $2,500 for the entirety of these charges.
Your Honor, just to clarify, he does have a previous battery, family violence, first offense out of Douglas County. There's just no disposition listed for that, and that was May of 2014. And he has a terroristic threat out of Douglas County, a felony terroristic threats and acts that it looks like it says not guilty, acquitted, December of 2015. And he has an armed robbery arrest in Douglas County from October 2014. Also, it was dead docketed August of 2015.
Okay, so you're adding, that's a lot of history out of Douglas. Okay.
And Judge, I would just reemphasize again, while I did hear each of those, I did not hear the word conviction on any of those. So while I do appreciate that being read, it's a very different being charged with something and being convicted of something. So I stand where I say you could have a surety bond set for all of these at $2,500.
Well, of course, the state's position feels as though a $2,500 surety bond, considering the circumstances that this involved, a mother and her 2 juvenile sons. The one son that was assaulted, he was 14. The officer observed a hole in the wall. He observed blood on the mother's shirt. The 14-year-old had a ripped shirt. He It started out as an aggravated assault. He strangled the mother and then strangled her 14-year-old. So we feel as though the $10,000 surety bond in total is more than reasonable. And her other two, there was 4 children that was present, and there was also a 6 and a 7-year-old that was present as well during this incident.
Okay. Do I need to sound for the victim? I'm assuming I don't see anybody with that name. Is the victim on the line at all? Is it Hall, H-U-L-L?
H-A-L-L, Miss Hall.
Oh, Hall. Is there a Miss Hall on the line at all? Okay. All right, I'm going to rule that and order the $10,000 surety bond, $3,000 on the battery, $2,000 on the simple battery, $1,500 on each of the 2 cruelty charges, and $2,000 on the simple battery for a total of $10,000 surety bond. There will be a stay away from 1974 County Line Road. No further contact with Ms. Hall. No further contact with the minor children of Ms. Hall, including victim A. Miller. And I don't know the name of the other one who's 13.
It's E. Miller.
E. Miller, okay. And no drugs, alcohol, or weapons or guns while on bond. And that's all I'll order at this time.
And Judge, could you please just repeat one more time, the cruelty to children? What was that charge?
Each of those, the 2nd degree and the 3rd degree, 1,500 surety on each of those, 1,500 surety.
Understood. Thank you.
All right, thank you.
Position 37.
Deputy, can you hold on 1 second?
Yeah.
He needs to speak to him.
Number 37.
Number 37 needs to be in the breakout with Zach finally.
And just to be clear, on 37, the state's going to ask for a reset. We submitted it to the DA's office for a felony transfer. From my understanding, the defendant is being held on another felony case on no bond, so it will be no prejudice to reset this to next Tuesday. But that's the state's request at this time, to hear back from the DA's office on the final decision.
All right. We're going to reset that. And Miss Grace, what's that date? Grace?
That
That's
will
gonna
be August the 1st.
I just looked at the same time. Thank you. So we're resetting that to August 1st. All right. And I see Miss McLeod has come on. Thank you, Miss McLeod. Good morning.
Good morning, Your Honor.
And Your Honor, that's where we're going. We're going to position 1, Mr. Marcus Booker.
All right. Her timing was perfect.
Yes, Your Honor.
All right. This is 16 CR 014855J. Marcus Booker, charged at 1 count of criminal trespass, the 2nd count of battery from April the 14th, 2016. And we are doing what with this case today?
Your Honor, I would like to ask the court to consider a bond for my client. The state has an offer on the table, but after speaking with my client, he doesn't even remember who the alleged victim is. He doesn't have any recollection of the incident. And this allegedly happened in 2016, Your Honor. My client is in jail and he's very sick. So I would like the court to give him a signature bond so he can get out of jail to deal with his illnesses, Your Honor, and we can pursue this case while he's out. It's a 2016 case, and he doesn't remember the place he's supposed to stay away from. He does not have any idea who the alleged victim is. He doesn't know anything about the case. And of course, I've had no discovery because I was just asked to represent him this morning. So I, just briefly looked at what it's saying online about this case, and I don't have much information myself, and I cannot in good conscience encourage my client, even though he wants to get out of jail, to take a plea under those circumstances.
And he's been in jail how many days?
72 days, Your Honor.
All right. State, what say you?
Judge, we would ask you to maintain the bond. In this case, the defendant shattered a television and struck the victim in the head, and also attempted to choke the victim. So we think it's a serious case. He does have 3 convictions two are for battery, one's for domestic battery out of Illinois. We think that it's a serious matter.
Nevertheless, this case is from 2016. My client has been sitting in jail for 72 days and has been unable to make bond because he's indigent and he's also ill at the moment.
What's the current bond?
I don't know that, Your Honor, because as I said, I just
Oh, do you have that, Mr.
spoke to
Walker or
him.
Ms.
I'll
Grace?
look it up. I just want to weigh in on this whole narrative of it's a 2017 or 2016 case. It is an older case.
2016.
But that's what happens when you don't come to court. And we all know that condition of your bond is that you have to show up to your court proceedings. So the fact that you will argue, hey, this person doesn't remember what happened. Hey, this is an older case because the defendant didn't show, and that should be viewed as a favorable fact. I don't have a response to that. That's what happens when you don't come to court. And on top of that, he was given a signature bond. So in my eyes, the court was already gracious enough initially 5 or 6 years ago to give the defendant a signature bond. He did not abide by the conditions of his bond. He did not come to court. He was in FTA status or absconded or was on the run, if you will, for over 5 years. And now that he's in custody, it's typically the court's position that if you FTA, we send it back to the division judge who issued the bench warrant. In this case, it was a jury trial calendar in 2017, I believe, in front of Judge Besson. His bond was forfeited in 2017. We would ask that it's sent back to Judge Besson to make a final determination on bond. He had a signature bond, he didn't show up, and now here we are in 2023. And I don't think it should be viewed in the defendant's favor that he didn't come to court over 5 years ago.
Your Honor, I would disagree with that. I understand what Mr. Walker is saying, but we are talking about someone who has been sitting in jail for 72 days. Even if he had gone to trial, there's a good possibility that he would not have been ordered, if he was found guilty, to spend 72 days in jail. The man is currently unwell. On humanitarian grounds alone, I am asking for this signature bond for him. I do have a good contact number, email address, and address for Mr. Booker. I am asking the court to consider giving him a signature bond when the totality of the circumstances are examined.
I don't know how
What's the state's bond recommendation, Mr.
to
Walker?
remain at SID, which is a 4,000, and he was already given a signature bond. So how you receive a signature bond FTA then ask for another one is beyond me, but he has
You
a
can
$4,000 surety bond.
You can if
not
you are
gonna
sick
remember.
and you don't even remember what happened.
I don't
Well,
remember
I'm
what happened
definitely
7
not
years
gonna
ago
do a
either.
signature bond. Definitely not gonna do a signature bond
It's a
again.
4,000. It's 2,000 on each count.
2,000 on
Looks
each.
like it's 2,000 on the battery and then 2,000 on the criminal trespass, according to the gentleman's screen.
Okay.
Well, I'm going to file for speedy trial for him because I think it's a shame that a man has been sitting in jail for 72 days on some old charges from 2016
I don't know.
without
You keep saying
anybody
52
even putting him on
days.
trial calendar.
Where you
I
getting
did
this
not represent him
from?
until today, but you can
Right.
bet
The
I'm going
gentleman's
to
screen
ask for
says-
speedy
The
trial for
gentleman's
him.
screen says 11 days. So, I mean, maybe you know something I don't know.
It says 72 days. That's what I saw.
Well, I'm looking at it. I'll be glad to share my screen.
Okay.
It says 11 days. It says he was booked July
Well,
7th.
why is the state's offer 72 days then?
Maybe he had time on a previous stint, but
Oh,
again,
so he
he was
spent
booked.
plenty of time on this charge.
Well, that's a different argument, and that's neither nor here nor there.
But that's
he
what
was
I saw
booked.
as the offer, Mr. Walker. I only
Yeah, but
just
that's different. That's different from how long he's been in jail, which you've said 10 times. He was booked 11 days ago.
well, what the offer from the state is
The offer does not relate to bond. We're discussing IALA factors, but typically when you have an FTA, we send it back to the division judge who issued the bond. And I'll just ask the
I
court.
understand all of that, but we're still talking about misdemeanors, and we have to remember that we're dealing with people, real humans. Mr. Booker is feeling he is sick. Isn't that a significant factor to take into consideration?
Hold on, only one person talk at a time. I can't hear both of you.
I've said
I
everything I
have-
needed to say. We typically send these back to the division judge. He's been in on 11 days. He's had a signature bond. He FTA. He didn't care to come to court. We're asking that the bond that was issued by Judge Besson is maintained and sent back to her division for a final determination.
All right, that is what I will do. Because some of these arguments again are for the next court appearance, but I am going to order the $4,000 surety bond, $2,000 on each charge, no drugs, alcohol, weapons, or guns while on bond. And this case will be returned to Judge Besson for further disposition on the FTA and other matters. It'll go back to the division judge.
And
All right.
yes, Your Honor, Judge Williams, Judge Mincy, I'm sorry, am I being officially appointed to represent?
As far as I
represent Mr.
know, I
Booker?
will, yeah, as far as I know, I will sign the, the affidavit and the order, certainly.
Yes, I'm going to enter my appearance on his behalf and ask to speed the trial for him today.
Okay, all right, that'll be fine. I will sign it. Thank you.
Thank you, Your Honor. May I be excused?
Yes, you may. Thank you.
Position
You're
6
welcome.
through
Mrs.
8.
Cloud, excuse me, will you make sure I get that bond order?
Yes,
Okay, thank you.
you're welcome.
Position 6 through 8, Dennis.
Okay.
Your Honor, if we could address position 8 first, I will need to speak with Mr. Dennis. After that, position 8 is the failure to appear, and I did submit proof of incarceration. So it's my understanding that that should be set aside.
I'd rather do all the cases together if you need to show that to someone. I don't like to do one case and then go back out and then come back and do the other two. I'd like to do all three together.
Your Honor,
Or
I
what-
just want, if I could just, I spoke with Mr. Walker this morning. It sounded like he received the proof of incarceration. We were fine with that. Can I just have confirmation of that so then I can speak to my client?
Mr. Walker?
That's correct.
Okay, thank you. Okay, so if I could please be placed, my laptop placed in a breakout room with 3 South.
All right. Is it Miss Champions, my Zoom master?
Yes, ma'am.
Good morning.
Good morning.
You've been busy. I hadn't spoken to you. Yes, could you put them in a breakout? Thank you.
Who needs to be in the breakout? Mr. Dotis in 3 South?
Yeah.
Or is it Mr. Dennis? I mean, Mr. Murphy. Mr. Dotis?
It'll be 3 South and Mr. Doty.
Yeah, 3 South and Mr. Dotis. Thank you.
Thank you.
And eventually I'll need to go over there.
Okay.
Thanks.
Uh-huh.
Your Honor, I have an announcement for position 16 and 17.
Okay.
He,
Mr. Green?
yes, he said he didn't want to come to court today, so he said Dotis waived his appearance, so I'm not sure.
Do we have a waiver or anything, Miss Grace, or do you know about anything, Mr. Walker?
I have not seen a waiver, but at the appropriate time, I would like the court to address the victim, Ms. Ross. She's been on all morning, so if we could just recognize that Ms. Ross was present and did wait for this case.
Yes. Good morning, Miss Ross. How are you?
Good morning. I'm well. How are you?
Good. As you can see, court is long and a lot going on. I appreciate your presence. I wanted to wait a sec. Oh, there's Mr. Dotis. Mr. Dotis,
Yes, Your Honor.
are you aware Mr. Green
Yes, I-
wants to do waiver?
I spoke with Mr. Green. He wanted to appear in front of court. We are going to waive his arraignment, but he did want to come down or to be present on the jail iPhone.
The announcement was that he refused to come out, Mr. Dotis.
I didn't have, is this position 15? Or what?
16, Mr. Green.
Position 16, I'm looking at it, says not guilty.
Yeah, that's just what the deputy announced. I think you had stepped away for a second.
Right.
Yes, I'm up here now, Mr. Dotis, and he refused to come out.
Well, if he refused to come out, Your Honor, I spoke with him. That was our plan today. I'm happy to waive his residence as well and go speak with them and see what's going on.
Okay, so if you're gonna prepare a waiver, send that to Ms. Grace. And then I will formally arraign him on position 16 and 17. That's what we're gonna do today.
Thank you, Your Honor.
Can you explain to me exactly what do you mean you're gonna arraign him on 16,
On
17?
both, are you the victim on both cases or just one case?
It should be both cases, yeah.
She's the victim on both?
Yes,
All right, okay. So the two cases, one ended in 4380E, which is one count of battery, family violence, and simple battery from July the 11th, 2023. And then the other case ending in 5538E is one count of criminal trespass and damage to property from July the 12th, 2022. He is going to be pleading not guilty and formally charged and arraigned, as we call it, with these cases. And he and his attorney, they understand that the maximum fine or penalty for each of these charges is up to $1,000 and 12 months in jail. So with them saying that he's pleading not guilty and wanting a jury trial, I assume it will be sent back to the division judge and further noticed for court. As long as your information is current and you are updated from the victim witness advocate, I'm assuming from the solicitor's office, have you been in contact with them?
Yes, Judge.
Yes, I have.
And they will keep you updated as to the court date. And if you want, you can check in with them as well, your victim witness advocate, just to see if there's any movement or disposition. But right now he is pleading not guilty and requesting a jury trial and waiving his appearance for court today.
He's here.
Oh,
No,
okay.
I went and got him.
110-110-111-111.
And so, Mr. Green, your attorney has spoken and stated that you wanted to plead not guilty. Is that correct?
Yes, ma'am.
Okay. And so you're pleading not guilty to the case ending in 5538, criminal trespass and damage to property from July the 12th, 2022. And are you pleading not guilty to the second case ending in 4380E, charge of one count of battery, family violence, and simple battery from July the 11th, 2023. And so both of those cases, I understand you wanted to plead not guilty and be noticed for a jury trial. Is that correct?
Yeah, ma'am.
Okay. All right. We have that. And I'm wanting you to know again that with each of these cases and these charges, the maximum fine is up to $1,000. The penalty being up to 1 year in jail. On each of those charges, they could either run concurrent or consecutive, whichever it ends up being, depending on the disposition or outcome of your case. And then you would have probation or other conditions possibly. But again, at this juncture today, we are formally charging you with these two cases, letting you know what they are, what the consequences could be if you are convicted on each of them. The state would have to prove your guilt beyond a reasonable doubt. And I am just letting you know that as your case now goes forward back to the division judge to be set for a jury trial at some point. All right?
Yeah, ma'am.
Okay.
Judge, may I interject?
Yes.
The victim in this case stated that the defendant has contacted her multiple times asking her to drop the charges. Would the court address
And
that,
they said
please?
they were gonna pull the jail call.
Hold
to
on,
see
don't,
because-
hold on, Ms. Ross. Please don't cut off the prosecutor. Let him finish. Okay, go ahead.
I was just asking if the court would address that while defendant and his counsel are here.
All right, listen, I want you to understand that you could suffer being given more charges if you continue to try to contact Ms. Ross. You have a no contact order. You're not to contact her in any manner. You're not to call her. You're not to email her. You're not to contact her in any way. And so if you continue to do that, more charges will be brought against you. Do you understand that?
Yeah, ma'am.
All right, stop calling her, stop contacting her.
No, because he already told him, he already was aware that he had a no bond order not to contact me multiple times. I even told his mom multiple times that he wasn't supposed to contact me. He continued to contact me from jail, and I continued to told the solicitor, and she said she would have the jail calls look back. So I don't see how he's getting like a second chance or getting like a second warning or a second notice when he already did it and he was already aware.
Ms. Ross, calm down a little bit, and I understand.
It's not.
I understand. I just want you to be a little calm, and the system will work through and give us an opportunity. He's not being given a second chance. He's not being let out of jail. We are stating that his case is moving and he has a right to request a jury trial or a bench trial. And at this point, he and his attorney are requesting a jury trial. And the jury trials go back to the division judge and they place it on a calendar. It won't be tomorrow and it won't be next week. So there is some delay, but there is certainly no impropriety or no injustice that's going to happen because of him seeking his right to jury trial. We just want you to keep in touch with it to make sure, again, that your contact information is there so that when it is time to go to trial, you will be notified to come to that trial and give your testimony and participate in the process. It is just going to be a little bit later than sooner because he is exercising his right to a jury trial. Okay, that's all that we're doing today. Nothing has been dropped, dismissed, but if he continues to contact you, it can be added. So you talk back to the victim witness advocate after today's court to see what they're going to do about the fact that he is continuing to contact you, okay?
Okay, and is there still a court date set for the 31st?
I don't know. Does anyone see that, Mr. Pilon? I don't know if that's not in this case, it wouldn't be.
Your Honor, I'm looking at Odyssey. That looks like it was a arraignment calendar date in front of Judge Morrison. So that may be reset if we waived his arraignment today.
Probably so. Probably not, Ms. Ross, but this afternoon or tomorrow, please give a call in. Do you still have the number to your victim witness advocate from the solicitor's office?
Yes, ma'am, I do.
Okay, call them tomorrow or Monday and or leave them a message so that they can look that up. But I suspect that date may be canceled for Monday, but try to get them this afternoon or tomorrow morning. You may be able to get them today and make sure that that date has been canceled or he's waived his appearance like he's kind of doing here, and there won't be a need for you to sit on the call the whole time.
Okay, and then they'll just let me know whenever I guess the trial is or whatever?
Correct.
Okay.
Correct. Okay.
Okay.
All right, but you're doing all the right things. You report it and let the solicitors know when he contacts you.
Okay.
Or tries to anyway. And obviously you just don't accept the calls, correct?
Okay, yep. And then so whenever we go to trial, I'll just bring like all the evidence from all pictures and videos and everything from
Oh,
everything.
they'll get that from you way before trial. Let them know that you have additional evidence that you need to get to them. They would like to have it sooner rather than later.
Okay, because I sent them multiple pictures, but it's tons of more evidence from multiple situations that I could send. So
well, I think they'll probably want to set up a time to meet with you and get those from you as opposed to emailing, but I'm not for sure of their policies, but stay in contact with them and try to see if you can bring them that evidence to make sure everything goes through. Sometimes emails get convoluted, so see if they can set up an appointment with you to come in and discuss.
Excuse me, Your Honor, this is Officer Norris. We actually running into the misdemeanor calendar.
I know, we gotta hurry.
Yes, ma'am.
Thank you.
In front of you, you got position 21 and 22, Mr.
And I'm sorry, Ms. Ross. So you're free to go, okay?
Okay, thank you.
Thank you. All right, thank you, Deputy. Say that again, 21, did you say?
Yes, it's going to be position 21 and 22, Mr. Corey Jackson.
All right, thank you.
Thank you.
This is 21 CR 0020005J, Corey Jackson, charged with 1 count of battery, family violence. Second case ending in 607 is the FTA from September 28, 2022. State. I'm sorry, Yes. state.
Yeah, I think you're correct, Judge. I'm just trying to find the plea offer. Here we go.
Okay.
Judge, the state's recommendation is 12 months to serve 40 days, credit for time served 20 days, balance probated, FVIP course, 40 hours community service, no further contact with Alexis Ford, and stay away from 2328 Campbellton Road Southwest. And Judge, we did speak to the victim. She informed us that she will not be on the Zoom, but she did agree with the state's offer.
All right. And Mr. McLean?
Certainly those terms are acceptable to the defendant. He asked the court to accept his negotiated plea, Your Honor. He stipulates the identification, venue, and factual basis.
All right.
On all the
And-
statement questions, we ran through every one of those questions and marked and signed those appropriately.
Right. All right, and so Mr. Jackson, you are Mr. Corey Jackson, correct?
Yes.
And you're wishing to plead guilty to the 1 count of battery family violence, is that correct?
Yes.
All right, and raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
And how do you plead to the 1 count of battery family violence?
Guilty.
All right, and you understand the terms and conditions of your plea?
Yes.
All right, and so, and you have been satisfied with the services of your counsel, is that correct?
Yes.
All right, and you give this plea free and voluntarily without any misunderstanding regarding the plea that you're about to enter or the conditions? It's free and voluntary, is that correct?
Yes.
Okay, all right, we'll accept that plea. And then the dismissal of position 22, is that correct?
Correct.
All right. All right, who do we have next, Deputy?
Thank you.
Uh-huh.
Next, Your Honor, we have position 30 and 31, Mr. Mitchell Ruffin, 30 and 31.
This is 21 CR 007272H. Mr. Mitchell Ruffin is charged with 1 count of theft by taking. And 31 is the FTA from 10/31/2022. All right, Mr. Walker, what do we have?
Yes, Your Honor. It's my understanding this will be a negotiated plea. I have the state's offer is 12 months to serve, 22 days, credit for time served, 11 days, balance wait, I'm sorry. I think I'm reading. This position 32?
30.
Okay, I
30
had
and
it right.
31.
I'm sorry.
Okay.
So 12 months to serve, 22 days, credit for time served, 11 days, balance probated with the conditions of an anti-theft course and a stay away from the Regal Avalon located at 3950 First Street in Alpharetta, Georgia. And then 31 will be null price.
Okay. Is that your understanding, Mr. McLean?
Yes, Your Honor, that is our understanding. That's correct. And he does ask the court to accept his negotiated plea. He does stipulate to factual basis identification of venue.
All right, Mr. Mitchell Ruffin, is it your intention to plead guilty to the 1 count of theft by taking?
Yes, ma'am.
All right, and you understand the conditions that you have to complete while on probation?
Yes, ma'am.
All right, and you're satisfied with the services and representation of your attorney?
Yes, ma'am.
All right, and you are willing to give up your rights today to testify and against yourself before a trial in order to plead guilty, is that correct?
Yes, ma'am.
All right, and so do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes, ma'am.
All right, I will accept your guilty plea and good luck to you while you're on probation.
Thank you.
All right.
Next, Your Honor, we have position 34 and 35. Mr. Moulton.
Your Honor, the correct spelling of Mr. Moulton's first name is K-A-M instead of N.
Okay, K-A-M-Y-D-E.
Correct.
And this is 21 CR 002071A. Mr. Moulton charged at one count of obstruction of a law enforcement officer from April 25th, 2021. And of course, position 35 is the FTA from January 18, 2023. State.
This will be a negotiated plea on position 34. It's a time served offer of 18 days. 35 will be a null price pursuant to the plea.
That's your understanding?
Your Honor, it is our understanding it's time served plea, and we ask the court to accept this negotiated plea.
All right.
Relate to the three elements.
Okay, good. Mr. Moulton, raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury? Can you hear me?
Can you say it again? You got to talk up.
I was swearing you in by raising your right hand. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
I swear.
Okay, all right. And just making sure that you understand your charge is obstruction of a law enforcement officer. You're satisfied with the services and representation of your attorney, is that correct?
Hey, sit up, man.
You got to sit up straight.
Why you sit up before you get reset?
You got to sit up straight.
Yeah. Go ahead, Your Honor.
Thank you. Mr.
All right. Are you prepared to take this plea today, Mr. Moulton?
Yes, ma'am.
Okay. And are you presently on the influence of any drugs or alcohol or medication?
No.
All right. You satisfied with the services of your attorney?
Yes, ma'am.
All right. And you willing to waive your right to the presumption of innocence and a jury trial or a bench trial?
She asked a question.
Yes, ma'am.
Okay. And again, has anyone told you receive a lesser sentence for pleading guilty?
Yes, ma'am.
Has anyone promised you anything to plead guilty?
Listen carefully to her question before you answer.
I plead guilty.
No, she said.
Has anyone promised you anything to plead guilty?
Has anybody guaranteed you anything, or do you understand what we're doing in court today?
Yes, I understand.
All right. And so do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes, I understand.
Okay. So as to the charge of obstruction of a law enforcement officer, how do you plead?
Guilty.
Okay. All right. I will accept your guilty plea, 18 days credit for time served.
Thank you, Your Honor.
All right. Thank you.
Next, Your Honor, we have position number 39, Mr. Thomas Taylor.
Okay. This is 23 CR 004419A. Thomas Taylor charged at one count of criminal trespass and damage to property and a second count of criminal trespass. Offense date is 7/14/2023. What are we doing, state?
I believe this is going to be a negotiated plea. The state's recommendation is 12 months to serve 28 days, credit for time served 14 days, balance suspended with the stay away of the incident location, which is the Fairburn Apartments. And if I can have 1 second, I'll give you the address. Address is 195 Fairburn Road in Atlanta, Georgia. Nothing further.
Okay. All right, is that your understanding? Mr. Finley?
Yes, Judge, that is my understanding. And just want to clarify really quick, Mr. Walker. So what is he pleading to? Is it the criminal trespass with these?
The criminal trespass can merge into the criminal trespass and damage to property.
Okay.
So it's just the one count.
Yes, that's fine.
Okay.
And yes, Judge, that is our understanding. We do stipulate the facts.
All right, raise your right hand for me, Mr. Taylor. You affirm the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yeah, ma'am.
All right, and so is my understanding that you wish to plead guilty to one count of criminal trespass and damage to property, is that correct?
Yes, ma'am.
All right, and so you're satisfied with the services of your attorney?
Yes, ma'am.
And it is my understanding that you wish to waive your rights today to the presumption of innocence, is that correct?
Yes, ma'am.
And by pleading guilty, you're waiving your right to remain silent and not testify against yourself?
Yes, ma'am.
And you're waiving your right to trial by judge or jury, whichever you would prefer.
Yes, ma'am.
All right, and has anyone promised you anything to plead guilty?
No, ma'am.
All right, and you understand that if you're currently on probation, it could be revoked because of your guilty plea, correct?
Yes, ma'am.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes, ma'am.
All right, I will accept your guilty plea. And you understand the conditions to stay away from those apartments at 195 Fairburn Road.
Yes, ma'am.
All right. That will conclude this case.
Position 6 through 8, Dennis.
All right, and this is Mr. Murphy's case?
This is my case, Your Honor.
Oh, okay. All right, this is 6 through 8. I have Mr. Clarence Dennis, charged of one count of theft by shoplifting, 21 CR 00715J. And on position 7, ending in 162Y, one count of battery, substantial physical harm, and then the FTA from February 27, 2023. What do we have, State?
Judge, I'm not sure if this is a plea or if we're
Oh.
arguing bond.
Right, Your Honor, for position 6, I believe this will be a plea. I do want to confirm jail time. The offer has him as having credit for 16 days. But when I look on Odyssey, he has credit for 14 days. Instead of serve 30 days credit for 16 days, I'd ask it to be worded as serve for 28 days, credit for 14 days. I think that's the same spirit of the offer.
Does the state have any objection to that?
Yeah, I don't object to that, Judge.
Okay.
And then there was restitution on the offer, so I'd ask the state if they have a restitution amount or if there could be no restitution.
I don't have that, Judge, so I'd strike it.
Okay.
Great. Thank you. And so position 6 will be a negotiated plea, and then position 7 will be a not guilty and waiver of arraignment. And then position 8, it sounds like we've agreed to set that aside.
All right. Is that your understanding, Mr. Pilon?
It is now, Judge.
Okay, sorry. All right. So we will go ahead and take that plea. Mr. Dennis, it's my understanding that you wish to plead guilty to the theft by shoplifting.
Yes, ma'am.
Raise your right hand for me. You affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, put your hand down for me. And it's my understanding with you pleading guilty to Mr. Dennis?
Yes, I'm there.
Okay. All right, it's my understanding that you're wishing to plead guilty to that one count. Are you satisfied with the services and representation of your attorney?
Yes, ma'am.
All right. And do you understand that by pleading guilty, you're giving up and waiving your right to the presumption of innocence?
Yes, ma'am.
You're giving up and waiving your right to trial by judge or jury, whichever you prefer.
Yes, ma'am.
And that if you're on probation, it could be affected by this guilty plea.
Yes, ma'am.
And has anyone promised you anything to plead guilty? All right. Do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes, ma'am.
All right, and I understand that on the second case, battery substantial physical, I will accept your guilty plea. And there's no restitution, and I guess again, that's a credit for time served, right, Mr. Pilon?
Yes, Judge, balance probate.
And balance probated, okay?
And Your Honor, we would request Mr. Dennis to his probation to terminate upon completion of the anti-theft class, and if this court could waive some of his probation fees. Currently does not have a job, so we want to give him time to get back on his feet, but he does know what's required of him and does have information for probation and the
All right, I will waive 6 months of the probation fees. All right, anything else?
Your Honor, could probation terminate upon completion of that anti-theft course?
I think they said it was going to be balance probated. I usually don't say terminated, I usually say suspended, depending on when. Does the state have any objection to it terminating or suspending?
Judge, I believe this is the same terminology. I would move to non-reporting after he completes.
Right. So it will be going to non-reporting once he completes the conditions.
Thank you, Your Honor.
All right.
Position 12, Mr. Gibson.
All right.
And Your Honor, I will need another breakout room to speak with Mr. Gibson briefly.
All right.
So, Your Honor, on that note, we're gonna go to position 47 and 48 in courtroom 2.
Judge, is the state able to put me in a breakout room?
Ms. Champion?
For the Taronio Jackson cases.
And which courtroom?
Where's the defendant located at?
Right. Which courtroom is the defendant in?
He's in courtroom 2, but Mr. Murphy, you need to speak to Mr. Jackson?
No, to the state on Mr. Jackson's cases.
Oh, okay.
So who wants to go in a breakout? Anybody?
I think Mr. Pilon is.
Mr. Jackson?
Yes, counsel. I was hoping to speak to you about those 2 cases.
Correct. Yeah, I think I show 3, but one of them's an FTA.
So Mr. Murphy and Mr. Pilon need to be in the breakout room?
Yes.
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 It's not sending me anything yet.
Okay, Your Honor, whenever you're ready, 47 and 48.
Okay. All right, Kevin Williams, this is 21 CR 007799Y, charged with 1 count of battery family violence, 2nd count of cruelty to the children in 3rd degree, and then the FTA on 11/14/2021. State.
Yes, Your Honor, the state's recommendation is 12 months to serve, 30 days, credit for time served with 15 days, balance probated with the conditions of a family violence intervention program. No further contact with the victim, whose name is Miss Morgan Hardy, and to stay away from the incident location. That address is 5716. I'll just spell this Harrier. I don't know if that's Harrier Lane in South Fulton. Nothing further.
Okay. Is that your understanding, Mr. Finley?
Yes, Judge, that is our understanding, of which we have agreed. He has agreed to take the family violence class. I would just ask that the probation fees be waived for a period of time, and that once he completes the family violence class, the probation could go to non-reporting status.
Okay. Well, he can go non-reporting once he's completed that.
There's no objection, Your Honor.
Okay. All right, Mr. Williams, is my understanding that you wish to plead guilty. Is that correct?
Yes, Your Honor.
All right, raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, let me ask you this. Are you satisfied with the services of your attorney?
Yes, ma'am.
And so you are wanting to plead guilty and waive your rights to the presumption of innocence. Is that correct?
Yes, ma'am.
And you're waiving your right to remain silent and not testify against yourself. Is that correct?
Yes, ma'am.
And you're waiving your right to trial by judge or jury. Is that correct?
Yes, ma'am.
Okay, and so has anyone promised you anything to plead guilty?
No, ma'am.
Okay, and you understand if you're on probation, your probation could be affected by this plea. Is that correct?
Yes, ma'am.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes, ma'am.
All right. I will accept your guilty plea. You've heard the conditions. And as long as you complete them, once you finish, you can go to non-reporting.
Okay, thank you.
All right.
Position 12, Mr. Gibson.
All right.
And I think that's Mr. Pilon's case, but let me see if 12.
What?
That's Mr. Pilon's case, so we can wait till he comes out the breakout room.
We don't
Oh.
know. Okay. Oh.
Your Honor, while we're waiting, this is Zakia Watson Cafe. Can I know who's assigned to Stephen John's case
Okay.
and what the offer is?
That's the
Okay.
probation calendar, Your Honor.
I'm sorry.
Yeah, sorry. I'm sorry. Yeah, it's the probation violation calendar.
Okay. Is that your case, Mr. Walker?
No, it's not. It's the probation case. So I'm not sure who was on for probation earlier.
It's me,
Oh, that's
Officer
right.
Allison.
And you said the last name is what? Johnson?
Johns,
Johns.
J-O, no, Johns.
Johns. Mhm.
I don't see that on the probation calendar.
It was an add-on, Your Honor.
Is it position 11?
Yes, I believe it'll be 11.
Is that the only add-on? Because I didn't see an add-on calendar. I apologize.
Yes, that's the only add-on.
Why don't you sound for it for me? Read the case number and if it's same, I appreciate it.
No problem. Case number 21CR004906F on the offense of disorderly conduct on July 20th, 2022. He failed to pay on court fines in a total, excuse me, $238, probation supervision fees of $280, victim crimes fund of $63. He did get a new offense of battery family violence on February 23rd, 2023 in Fulton County. He did not complete 2 days of anger management, and he violated a no contact order with the victim by the name of Yolanda Gray. He's been in custody for 2 months and 24 days. We are asking for time served.
All right. And Miss Watson Cafe?
I didn't have the offer, Your Honor, so I need to speak with him again. We do have some mitigating factors. My understanding is he was in the hospital for about 5.5 months. And shortly after that, he got picked up on this. So some of the inability, that would at least address some of the inability to pay some of the fines. And his inability to complete anger management. To my understanding that he did do the remaining, he did complete community service hours that was required, and I believe he had to complete a FBIB course. So I just need to speak with him, Your Honor, and see if he wants to move forward with this.
Well, I can tell you, I will accept the probation's recommendation and
okay,
give him credit for time served and not broken. If that changes it.
Mr. Johnson, you want to speak to me again about it, or do you want to accept the offer? It's a time served offer.
Yeah, ma'am.
Okay, so we can move forward, Your Honor.
Okay. All right. And so you understand that, and we hope that now when you get out, you'll be able to comply with the conditions, okay? So what I'll do is I'll waive 6 months of your fees, probation fees, and help you kind of get back on your feet, okay?
Yeah, ma'am.
All right. All right. Good luck to you.
Position 12.
Thank you, Your Honor.
You're
May I be
welcome.
excused, Your
Can
Honor, before
probation-
you move?
Yes, you may. And yes,
probation
probation.
be
Thank you, Your Honor.
Yep. Thank you, probation.
Thank you. Have a good one.
You too. And I'm sorry. Go ahead, Deputy.
Position number 12, Mr. Gibson.
Okay. And I think I've already sounded for Mr. Gibson, case ending in 5338Y.
We need Mr. P-Line. He's supposed to be joining us right now.
Okay.
So let me know when you come back.
Okay. He's connecting now.
Magic touch.
All right, we're ready on Mr. Gibson. Is this going to be a plea?
Your Honor, I believe we might want to address Mr. Dennis Murphy's client because he's the last one in the courtroom, but I'll leave it up. to
Thank you, Angelo. Appreciate it because I'm running out of battery time.
Okay.
Judge,
Yes.
Judge, on the, Mr. Jackson has two cases. I represent him on the older case, not the new one. And if we were to enter a plea on this older one, it would jeopardize the newer one, whether I represent him or a new attorney does. So at this point, the state said they could not consolidate two for plea today, that the second one might end up going to Superior Court. So I don't think that we should be doing anything today. And I'm ready to tell my client that it should just go back to the division judge. And I will go see my client and tell him what the state's position is currently.
Okay, you're talking about 24. The deputy sounded for 12. But I do hear you on 24. So 24 is just going to return further notice for trial and return to the division judge, which is Mr. Jackson.
Yes, which is Geronio Adele Jackson. And I represent him on the 21 CR case.
Yes, Judge, just to be clear, Mr. Murphy represents Mr. Jackson on position 23.
It's 23, yeah.
Correct.
Yes, which is the 21
Position
CR case.
24.
Sorry.
Position 24 is the same person. I know there's a middle name there and it's not on position 23, but that is
I
the
see.
same person.
It is.
Sorry for confusion, Judge.
Okay. All right. So both of those are going back.
Yes, Judge.
Okay.
Since he's already represented by conflict counsel, do we need to appoint him for position 24?
Judge,
So,
Judge, I'll file an EOA tomorrow on that, and then I'll go see him and tell him what the events of the day have brought us.
all right.
Thank you, Judge.
All right. Thank you.
Appreciate it. That's all I have.
Okay. All right. And now we can go back to 12 or no?
I'm ready to go.
I know. We're sorry.
Thanks for holding, Blonde. We're ready on 12.
All right, Mr. Gibson.
Hi, Judge.
Okay. And you're Mr. Anthony Gibson?
Yes, I am.
All right. This is 22 CR 005-338Y, one count of theft by shoplifting. And what are we doing? Is this a plea?
Your Honor, this, I believe, will be a negotiated plea. There is a $500 fine, so we would request that to be converted to community service hours. I believe 50 hours, as Mr. Gibson is currently homeless. And we want to make sure that he's able to complete the conditions of his probation.
Okay. Okay.
Judge, my position is I don't think I can do that. The statute requires a $500 fine.
On the shoplifting mandatory.
That's fine, Mr. Pilon. We can.
I'm sorry?
That's fine, Mr. Pilon. We can agree to that.
Okay.
Okay. All right. So we're going to agree to the 50 hours of community service.
Yes, Judge.
All right. Anything else?
Nothing further, Your Honor. We do stipulate to the factual basis, venue, and ID for the purpose of this plea. As stated, Mr. Gibson is financially challenged and homeless. So if Your Honor could give him a break on probation fees and switch him to non-reporting status upon completion of all conditions, Mr. Gibson would greatly appreciate it.
All right. I will waive 6 months of the fees. And he can go non-reporting after he's completed the condition, the 50 hours of community service.
Thank you, Your Honor.
All right. And Mr. Gibson,
Yes, Your Honor.
raise your right hand for me real quick. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, I do.
And how are you pleading to the theft by shoplifting?
Guilty.
All right. And you understand, again, that you're waiving your right to the presumption of innocence?
Yes.
Put your hand down for me. And that you're waiving your right to a trial?
Yes.
And that you have not been promised anything to plead guilty, is that correct?
Correct.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes, I do.
All right, I will accept your guilty plea and work on that community service, okay?
Yes.
So
Okay.
Judge, we're not going forth with the theft course?
Oh, I'm sorry, in the theft course, yes. I'm sorry, it was two things, theft course and then the, we converted the fine to community service, correct?
Yes, Judge, and we were asking for a stay away from the incident location.
And stay away from the incident location, I'm sorry.
And Mr. Pilar, can you give me the time, how many days he served?
We were asking 12 months served 30, credit for time served 32. I don't know if I need to square those numbers, but yes, credit for 32.
And I looked at his credit. I only had credit for 18 days, but that's still enough time to get time served. So it should be fine.
So how do you want it, Mr. Dotis?
I worded it as served 30 days, credit for time served of 18 days, which is still enough time. If that works for everyone. Because I only see the 18 days for the FTA related to this case, so I'm not sure where 32 days came from. But if 18 days works for everyone.
Yes.
That's fine.
Okay.
What's her name?
All right, nothing else, I will accept the plea.
Yes.
Position 42, Mr. Webb.
Okay.
And Judge, I just had to ask Mr. Webb something very briefly. Mr. Webb, I'll go ahead and tell you, I can call you privately, but I got the family violence class removed and put on anger management.
What does that entail?
It's 6 weeks as opposed to, I believe the family violence is 24 weeks. So
Okay. Okay. Can I say this that
Mr. Webb, I strongly recommend you not to say anything.
Okay, that's fine.
Judge,
That's fine.
If I could call him or be in a breakout room with him very briefly.
Do they have a method for you to do that real quick? But they're pushing me, so we gotta hurry.
Okay.
Will we be able to get back to this today? Right in a minute.
Yeah, we can. Mr. Webb, I just want to verify. So we're going to move forward with the plea. So
okay,
you won't have to do family violence. So does that sound good?
I did a year of rehab past year with the anger management classes. I mean,
no, I understand. That's going to be the
okay. All right. All right. Okay, let's do it.
We'll go ahead and move forward, Judge.
Let's do it.
Okay.
So what am I being charged with?
I'm getting ready to read that to you. It's Mr. Webb, is that correct?
Yes.
And it's 19 CR 007528Y. You're being charged with 1 count of battery family violence. The offense date is August 23rd, 2019. Is that your understanding?
Yes, ma'am.
And I'm understanding that you want to plead guilty to that. Is that correct?
Yes, ma'am.
And the conditions will be what, Mr. Walker?
It's going to be 12 months to serve, 28 days, credit for time served, 14 days, balance probated with the conditions of a 6-week anger management course, no further contact with the victim whose name is Leonard Kraniak, and a stay away from the incident location, which is, Your Honor, if I just have 1 second.
Mm-hmm.
We can come back to it, and I can.
We'll just say the incident location.
Yeah.
And I just want to double check. Is that, Mr. Webb? Is the incident location? Is that where you reside, I believe he was renting from you, is that correct?
Yeah, I don't live there anymore.
Okay. all right.
Okay, it's
That's not-
214 Mayfield Road in Alpharetta, Georgia.
Okay, and you don't reside there, Mr. Webb, is that correct?
No, that used to be my mother's property. She passed away and I live there.
Okay.
Okay, understood.
All right, that'll be fine. And raise your right hand for me, Mr. Webb. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, yes.
Okay, you can put your hand down. And so again, you're satisfied with the services of your attorney?
Yes, ma'am.
And has anyone promised you anything to plead guilty?
No.
All right, and so you understand that you're giving up or waiving your right to the presumption of innocence?
Yeah.
And you're giving up your right to trial by judge or jury?
Yes, ma'am.
And
Am I
you,
getting out of here today? Am I getting out of here today? Or tomorrow?
it'll be within 24 hours.
Okay,
The jail
thank you.
has to process you. I can't
Yes, ma'am.
guarantee, it could be
I
2 in the
I
morning.
understand. Thank
Right.
you.
All right. And so again, you're giving this guilty plea freely and voluntarily with the full understanding of the charge against you, correct?
Yes, ma'am.
All right. So as to the one count of battery family violence, how do you plead?
Guilty.
All right. And so again, you've got the stay away, no further contact, I believe, with the victim in 6 weeks of anger management. Is that correct?
Yes, ma'am.
Okay. All right. Good luck to you and I'll accept your plea.
Thank you, ma'am.
And Mr. Webb,
Yes,
I see you get quick contact information. What's your phone number, sir?
it's 334. 334. God. 334 434 4176.
So 334-434-4176.
Yes.
All right.
Yes.
And then what's your mailing address?
I'm staying at Sonesta Suites in Alpharetta. It's
All right. Well, I'll contact you. We'll get a better address. Okay.
yeah, there you go.
Thank you, sir.
All right. Good luck to you.
Thank you.
Uh-huh.
Good morning, Your Honor. This is ACDC.
Yes.
Before you is position 26, Desiree Jenkins.
Okay.
They dropped it.
This is 23 CR 0044008D. Desiree Jenkins, charged with one count of willful obstruction of a law enforcement officer.
I don't want someone to come.
Offense date is July 13, 2023. All right, what are we,
This is a
Doing-
negotiated plea, Your Honor.
huh?
Yes, it's going to be an offer of time served. I believe the defendant has been in custody for 15 days.
Okay. All right, anything else?
Your Honor, she stipulates to venue, identification, and factual basis. She and I fully discussed my advice to her about going to trial, and she has the right, of course, to plead guilty to time served if she exercises that judgment on her behalf, and she understands what she's doing. So she asked Your Honor to accept her negotiated plea.
All right. And Ms. Jenkins, is that your desire today, is to plead guilty?
Yes, ma'am. If the stipulations are that I get time served and I get to go home, like
Yeah.
that if that's the agreement, then yes, ma'am, I do willfully agree to plead guilty today.
You will go if there's nothing else that pops up and if nothing's holding you.
Right.
Okay, but I am not sure that that's, well, I've been in Georgia for 15 days and I'm not from Georgia, I'm from Florida. But I also have a misdemeanor court case in Florida. You know what I'm saying? That I'm not exactly sure whether or not I might have missed that court date being here in Georgia. So
We have no control over whether a Florida court has issued a warrant that we are unaware of.
well, I mean,
We have no way of knowing.
you'll know before I get released though, right?
Here's what
But it's the
happens.
same day. I'm right here with you right
Ma'am,
now.
may I answer your question? The jail record room always checks before you go out their door. They check one more time for any warrants outstanding.
But you can't check right now while I'm here with you guys.
I'm not part of the record room and that's not, we don't, no.
Okay.
Thank you.
But does Florida expedite?
Uh,
Depends on what your one going.
Yeah, it
Let's,
depends. I was
if
gonna
we-
say.
We
it
need to do a
depends.
breakout room for further discussions. We can do that.
I don't know. No, I just want to move forward. I don't know.
Yeah, I'm
Sorry.
not a member of the Florida Bar.
Okay, so let me ask you this, Ms. Jenkins, are you willing to plead guilty to this willful obstruction count
Yes,
today?
ma'am. Yes, ma'am.
Is it free and voluntary? You understand what you're doing?
Yes, ma'am.
Raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, you can put your hand down. And so again, are you satisfied with the services of your attorney?
Yes, ma'am.
Okay, and are you agreeing to waive your rights today by pleading guilty and waiving your right to the presumption of innocence?
Yes, ma'am.
Okay, and do you understand that by pleading guilty, you're waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
And do you understand that by pleading guilty,
you
you're
just give me
giving up
that?
your right to trial by judge or jury?
Yes, ma'am.
And you're also prepared to agree to do that today, correct?
Yes, ma'am.
Okay, and do you understand that if you're on probation, it could be revoked because of this?
Yes, ma'am.
You are. All right, and you offer this guilty plea freely and voluntarily with the full understanding of the charge against you, is that correct?
Yeah. Yes, ma'am.
Okay, all right. And so I will accept your guilty plea, credit for time served at 15 days, and I don't think there are any other conditions. Is that right, State? There's no other?
There's no other conditions, Your Honor.
Okay, all right, just a time served plea. All right, I'll accept your plea and they will begin to process you, okay?
Thank you.
All right, you're welcome. Take care.
Next, Your Honor, we'll have position 9 and 10, Shamika Ezel.
Okay,
Ms. Ezel, come on up, have a seat.
all right, Ms. Ezel, I have two cases. The first one being 22 CR 005025J, one count of simple battery from July 21st, 2022. Second case is your FTA from January the 5th, 2023. Is this going to be a plea?
Your Honor, this is going to be a not guilty plea and waiver of arraignment on position 9. We would request to set aside the FTA on position 10.
All right, State.
Judge, I apologize. I had a hard time hearing Mr. Jodas. Guess I need to get some better
Say
speakers.
that again, Mr. Dotis.
Sorry, I'll try to speak into the court microphone. It was,
Mhm.
for position 9, it's going to be a not guilty and we're going to waive arraignment. For position 10, we're going to request to set aside the FTA.
I believe that happens just by operation of law, Judge.
I mean, she's here, right?
Wait a minute. No, that's not how that works. The defendant FTA, and I looked it up in Odyssey to see who issues the bench warrant, but what we typically do is send it back to the division judge who issued the bench warrant. In this case, she FTA'd on
January 5th.
January 5th of 2023. It looks like the bond has already been forfeited. She had a $2,000 surety bond, so as is the court's standard practice, is send it back to the division judge who issued the bench warrant to make a final determination on bond. And in addition to that, we had the victim, Ms. Tabitha Rowe, here. And when she bonded out the first time, there was a condition of a stay away from Camelot condos or Camelot apartments. The defendant returned right back to that subdivision, if you will. So there is a concern for safety of the victim. I'll let Ms. Rowe address the court at the appropriate time. But this defendant has FTA. Judge Besson did issue the bench warrant, and we would ask that it's sent back to her division for any modifications.
Okay. All right, that's fine. Ms. Rowe? I thought I saw her earlier.
She just had her camera
Yeah.
on. If you could turn your camera back on, please.
It's,
All right, Ms. Roll. I
it
don't
should
know-
be on now.
It is. I can see you. I don't know if you wish to address the court today. It's
Okay.
not much. It's not much that is going to happen today because the case is going to be sent back to the division judge on the FTA. But Ms. Ezell is pleading not guilty today. So there's not going to be a plea and she's waiving her arraignment. And so there's nothing else that I can do for the case today. We appreciate your time and staying on this whole time. And but there's not going to be any additional things that I'm going to do today.
So basically, what does this entail? She'll go back to the other courts.
The case,
Or-
yes, the case, and she will be returned to the other courts. But right now she's in on her FTA bench warrant pickup for failing to come to court. And so that will be heard by the other division judge.
So at that point, I guess, will I be contacted?
Yes, definitely. Stay in contact with the victim witness advocate for the solicitor's office, and they will continue to contact you for other court dates as they did with this court date.
Okay.
All right.
I guess Mr. Walker can explain things to me later as well.
You
I
can.
can give you a comments, bro.
Yes.
Okay, thank you.
All right. Thank you.
You both have a wonderful day.
All right. You too. Thank you for your time.
Mhm.
All right. Anything else, counsel?
Nothing further, Your Honor, and I'll submit that waiver as soon as I leave the courtroom.
All right. Thank you.
Come on, Ms. Fields. Position 11, Ms. Fields. And Your Honor, for position 29, I have to take these three ladies back, and I will be back with Ms. Lovelace.
Okay. All right. This is 23 CR 004421A. Serena Fields charges 1 count of criminal trespass and damage to property, 2nd count of criminal trespass on July 14, 2023. And what do we have?
Yes, Your Honor, this should be a negotiated plea. We do need to confirm the jail time, though.
Okay.
I know the offer gave her credit for 24 days. I have her down as having credit for 14 days as of today. So we'd ask it to be worded to serve 28 days, credit for 14 days.
State have any objection?
That's
No,
fine.
Judge.
That's fine.
All right. And the criminal trespass merging, so it's just the 1 count.
Yes, Judge.
Okay. All right, and what are the conditions? Or what's the plea?
So it'd be credit for time served to balance probated, and a stay away from 195 Fairburn Road Northwest, and it's in Atlanta.
Okay. And just a stay away condition. Is that your understanding, Mr. Dotis?
Yes, Your Honor, that's our understanding. Because there are no conditions, we would just ask it to read as balance suspended.
State?
Judge, I apologize. I cannot hear him.
Oh, yeah. He was saying that he wanted to know if the balance could be suspended.
No, Judge, I said balance probated.
Okay, balance probated.
And again, Your Honor, there are no conditions. So usually when there's no conditions besides a stay away, we word it as balance suspended.
We can do a suspended balance. That's fine.
Okay. And that's again because there are no conditions. Well, the only condition is stay away. And so you understand that, correct, Ms. Fields?
Honor, I do.
Okay. All right. And is your desire to plead guilty to the one count of criminal trespass and damage to property with the stay away condition?
Yes, Your Honor, I plead guilty. So.
Okay.
those
All
charges.
right. Raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, Your Honor.
All right. And your desires to plead guilty and waive your rights to the presumption of innocence, is that correct?
Yes, Your Honor.
Are you satisfied with the services of your attorney?
Very much so.
And you know, agree that by pleading guilty, you're waiving your right to trial by judge or jury, correct?
Yes, Your Honor.
And did anyone promise you anything to plead guilty?
No, Your Honor.
And do you understand that if you're on probation, it could be revoked or affected by your guilty plea?
Yes, Your Honor, I do.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes, Your Honor.
All right, I will accept your guilty plea. And again, you understand the conditions of the stay away.
I do.
All right, good luck to you.
A question? Do I go
Yes,
home today?
as soon as they finish processing you within 24 hours or so.
Okay, thank you.
Yeah.
Your Honor, I'll be right back with Miss Lovelace.
Okay.
Thank you. Do I get up?
We do Lawson.
Yes.
Lawson. And Your Honor, we are ready in courtroom 2 for the add-on 1, Mr. Bernard Lawson, while we're waiting for Officer Milton.
It's great.
Yes, Judge.
Can you read that add-on one for me, please?
Okay.
This is that.
You have it, Mr. Walker?
Oh, the case number?
Mm-hmm.
Yes, Your
We're
Honor.
sending you the calendar as well, Judge. So-
It's
Is it
20
only one?
It's only one. It's 23 CR 004037C.
All right. And what are we doing?
I believe it's going to be a bond hearing. The defendant currently has a $4,000 surety bond that was set by Your Honor back on May 27th of this year. I believe that this is his first arrest, but after reading through the report, it stated that at the time of this incident, he was wanted out of DeKalb County for another battery case. Back to this incident, law enforcement was dispatched to 4312 Scott Circle in East Point, Georgia. They spoke to the victim's neighbor who had called 911. She advised that the victim is Nairobi Cooper, came to her address that morning yelling for help due to her boyfriend, Mr. Lawson, attacking her. He had grabbed her by the face and pushed her. The officer did observe a cut under the victim's eye. Again, the court issued a $4,000 surety bond and no further contact and a stay away from Ms. Nairobi Cooper. We ask that that bond remain intact.
Okay. And Mr. Dolan?
Thank you, Your Honor. Mr. Lawson is 17 years old. He has been in custody for the past 32 days on a $4,000 surety bond that he cannot afford. He has been in the state of Georgia for the past 4 years. Before that, Florida, where he was born and raised. I do have a good address for him where he'll be residing with his mother. I have spoken with his mother, Miss Cherie Harriet. I spoke to her on the phone. She wanted to be in court today to show support, but she did have work that she could not miss. But she did verify the address that Mr. Lawson gave me. It is separate from the incident location. And I've been told that it's an address that the complaining witness has no reason to go to, so I don't think there'll be any issues with any further contact. My client is clear on the stay away from the incident location. He wants his GED. He was last working at the GDOT rest stop where he was a cleaner. Mr. Lawson, because he's 17 years old, he has been in separate custody within Fulton County. He's been unable to make phone calls. He's been stuck in medical, we're told. We haven't been able to reach him. If you look at the calendar, you'll see that this was his 4th reset. He was recently transferred to Union City, where they didn't even know to bring him today until we spoke with officers to have him brought over physically because they don't have the capabilities to have him on Zoom. When I spoke with Mr. Lawson, he still has been unable to communicate with anyone outside at Union City. So we do have concerns with all of the movements within Fulton County on making sure that we're aware of his safety and keeping in good contact. So we are requesting a signature bond. Mr. Lawson is clear that he still has another hold that he will be released to. And mom is on fixed income, which is why she hasn't been able to afford this Fulton County bond.
Where's his other holdout of Mr. Walker? Do we know?
Well, at the time that this incident occurred, it said he was wanted out of DeKalb. But let me check the jailing screen to see if there's any additional information.
And I believe that DeKalb County hold is the only other hold.
Okay.
Yeah, it's a hold out DeKalb. That's the only other hold. And that's for another separate battery.
And he's been in since May 27.
Yes, 32 days.
All right, I'm going to issue the signature bond so that he can go to DeKalb. He can only be released to DeKalb County, so that they can pick him up and deal with his case over there. I'm going to issue that $4,000 signature bond. For him to be released to DeKalb County only.
And we just ask that to stay away and then no further contact will be included.
Right, and to stay away still from the incident location, no further contact with the victim, no drugs, alcohol, weapons, or guns while on bond. Anything else, attorneys?
Nothing from the state.
That's gonna be through the jail, Judge?
That was my question.
I guess so, Mr. Walker. I just want to make sure he's picked up and doesn't get out because he's not picked up.
Okay, I understand.
So, if I do it through pretrial, then he's going to have a cosigner and all that. So I will do it through the jail, but there needs to be strong all caps language only to be released to DeKalb County for his hold.
Understood, Your Honor. I'll make sure that language is explicit.
Yes. All right, that'll do it.
Thank you, Your Honor.
Thank you.
So any announcements on position 32 and 46?
Your Honor, we're ready with position 29. Deanna Lovelace.
Okay. This is 23 CR 004426D. Kiana Lovelace, charged with 1 count of simple battery, offense date July 14th, 2023. And what do we have?
Yes, Your Honor, this is gonna be a negotiated plea, I believe. The state's recommendation is gonna be 12 months to serve 26 days, credit for time served 13 days. Balance probated with the conditions of an FFIP course and no further contact with the victim, Sunny Lovelace. Is this Mr. McLean's case? or-
Yes.
Oh.
All right, is that it?
Nothing further from the state, Your Honor.
Okay, Mr. McLean?
Your Honor, she asked the court to accept her negotiated plea of guilty. Those are the terms she expected to hear. She stipulates the 3 necessary elements. Your Honor, I had 2 phone numbers I've been trying because she sincerely believes that this would be, if her daughter Sunny were on Zoom, she would be telling the court that no further violent contact would be fine as opposed to no contact at all. But I've been trying one relative of the older generation. I've been trying a boyfriend, and I'm getting that the phone numbers are full and can't take a voicemail right now. And it's just unfortunate that I can't reach anybody right now. If the state had any contact with Sunny, did y'all have the impression that no further violent contact would be okay in this situation?
We were unable to contact her as well, which is the reason why we put no contact, because we haven't had contact with her.
I understand the state's caution. I would ask the court to consider the notion that it is likely in a situation like this, that no further violent contact would be sufficient, but I don't have a witness, Your Honor.
I guess we can proceed. And what's the state's argument against it?
That we haven't had contact with the victim, so we don't want to agree to having the victim having contact without confirming with the victim first.
Okay,
Just,
yeah. So we would have to, at this point, say, no further contact until we had a bond modification order, or request for it. But with the plea, I would have to continue with the stay away.
Right. And Your Honor, we did discuss this yesterday at the visitation booth. Ms. Lovelace, because Sunny's not on Zoom today, you do understand that to have contact with her, somebody would have to approach the court to modify this portion of the sentence order later on. You understand that?
Yes.
Okay, you willing to still go ahead with the plea by order, no further contact with the victim?
Yes,
Okay, what relation are you to the victim?
it's my daughter,
Okay, how old is she?
20.
And does she live with you?
No, ma'am.
Okay, so you could stay away until either the case is over or if the bond was modified, correct?
Yes, I can stay away. I can do that. That's one thing I can do.
Okay. All right, you ready to take your plea?
Yes, ma'am.
All right, raise your right hand for me.
I can't rape both of them. I got these handcuffs on.
I understand. Just do the best you can. Do you affirm
Is
that
that
the
enough?
Yeah, that's good enough. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
Okay, all right. You can put it down, just making sure again that you want to plead guilty to 1 count of simple battery. And you're satisfied with the services of your attorney?
Yes, ma'am.
And you've not been promised anything to plead guilty?
No, ma'am.
And you are freely giving up and waiving your right to trial by jury by entering this guilty plea today. You understand that?
Yes, ma'am.
And you understand that you're giving up or waiving your right to the presumption of innocence.
Yes, ma'am.
And you're also giving up and waiving the right to remain silent and not testify against yourself.
Mhm.
All right, and you're prepared to waive these rights today, right?
Yes, ma'am.
All right, and again, you understand if you're on probation, it could be affected by this guilty plea.
Yes, ma'am.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes.
All right, I will accept your guilty plea. And again, you've heard the conditions, the main one being to still stay away and
Yes,
have
ma'am.
no contact with your daughter who's a victim in this case, okay?
Yes, ma'am.
All right.
Judge, can I get the stairway address, Mr. Walker?
It actually wasn't a stay away, which is a no
Oh,
for the
that's-
contact. This
I don't
happened-
know where she lived. I don't know where she lived, and I don't want to know either.
This happened at like a convenience store, so.
Yeah,
Oh,
at the store. They told me to stay away from the store.
So it's
Okay.
just a no contact with the person. She can go back to the store.
Okay.
Right. Mm-hmm.
Okay.
All right, if there's nothing else, that'll conclude this matter.
Thank you.
Oh, I'll be going home today?
It'll be processed today. As long as there's no other holds within 24 to 48 hours,
Okay.
give them time to process you.
Yes, ma'am.
All right, good luck to you.
All right, thank y'all. Thank you, attorney.
Thank you.
May I be excused, Your Honor?
Yes, you may. Have a good one.
Thank you. Bye-bye.
Bye-bye. Who do we have left? No one?
On the calendar, there was Frankie Lamar, I believe it may be pronounced Monet. I represented him on June 20th on a June 2023 one count of battery, not family violence, but just one count of battery. It turns out that there's also a separate case that is from June. It's a similar date, but it's a different year, 2021. And I wondered if Mr. Walker could call me on the 2/23/92. I want to make sure that that's either a different victim or a different time of day or a different circumstance. Because of course, we have the complete detail on the one we pled to a few weeks ago. I have the time of day and exactly where.
Is there any way you could just put the case numbers in the chat, Mr. McLean?
The phone call would be better because I've got, I want to ask you about a couple of things.
Okay, just give me, I'll call you in just a second.
It went through East Point Jail. Thank you.
Okay, give you a call momentarily.
Then I'm holding on 46, Judge.
So it's my,
Okay.
so, so 46, my understanding is at Union City. And I know last thing Officer North said is that one's probably gonna have to be reset, because I believe there was someone brought over from Union City and he was not one of them. Yeah. So it sounds like number 46, Mr. Williams is still at Union City.
And there's. Everybody?
So if we could.
We set to next Tuesday, August the 1st, Judge, next Thursday.
No, if we could.
Go ahead, Mr. Dotis, whichever.
I'll let it. Yeah, if I may, Judge, if he can be reset to Tuesday, there's nothing else holding him and it's a time served offer, so he would have
Okay.
been let out today. So if he can be on Tuesday, so he can.
All right. We'll do that.
You're getting into this? Yeah. Now, Your Honor, the same is also true of Mr., if I'm pronouncing his name correctly, Monet, M-O-N-E. He
Okay.
is also at Union City, and he is also being offered, I believe, time served. I think it was within one day of that. That might have been a typo, I'm not sure. So it was either one day extra or within time served. And I haven't seen him today.
Please state your name after the tone and go for.
I personally will not be here next Tuesday, but I do have the paperwork on the 2023 case.
Okay. So we'll reset that as well, both of those,
Right, as soon as possible in his situation.
and you can put them both on for Tuesday, Miss Grace.
Yes, ma'am.
Okay. All right, next. Or is that it?
That's it, I think, Judge.
Yeah, I think
Except
that's
for the
it.
competency. We're going to the
Right.
competency.
Right.
Do you want me to go over this calendar, Judge?
You can ask the other attorneys. I know you and I will be fine, but they may want you to see what Mr. Walker wants.
We can go, I think, just for best practices, yes.
There you go. We're gonna be
Okay.
consistent and do what we always do.
But not for me, though. No.
It's for me, Your Honor.
Position number 1. Reset jail jury at a modified bond of $4,000 good bond. Position number 2 and 3, reset further notice. Position number 4 was a plea. Position number 5 was a non-pros. Position number 6 was a plea. Position number 7 and 8, reset jail jury. Position number 9 and 10, reset jail jury. Position number 11 is a plea. Position number 12 is a plea. Position 13, non-pros. Position 14 was a plea. Position 15, non-pros. Position 16, reset jail jury. Position 17, reset jail jury. Position 18 was a plea. Position 19 was a plea. Position 20 was a non-pros. Position 21 was a plea. Position 22 was non-pros. Position 23 and 24, reset jail jury, and 25. Position 26 was a plea. Position 27 was a plea. Position 28 was non-pros. Position 29 was a plea. Position 30 was a plea. Position 31 was non-pros. Position 32 and 33 would be reset for 8-1 SAP. Position 34 was a plea. Position 35 was non-pros. Position 36 was a plea. Position 37 will be reset 8-1 SAP. Position 38 is an amended bond, reset jail jury. Position 39 was a plea. Position 40, reset further notice. Position 41, reset further notice. Position 42 was a plea. Position 43 and 44, reset jail jury, and 45. Position 46, reset 8-1-23 SAP. Position 47 was a plea. Position 48 was non-pros. Any questions, concerns, or comments?
What was 33 for some reason?
Reset 8-1, that's the FTA from position 32.
Oh, that's right. Okay.
And then Ms. Grace, I just have position 8. Position 8 is going to be no pros for legal excuse.
Position 8.
Yes, ma'am.
Is going to be non-pros.
Yes, ma'am. The defendant was incarcerated in a different jurisdiction. So that FTA, I believe position 8 is an FTA.
Correct.
It is. Thank you.
Yes, ma'am.
Please send over all paperwork to Melissa.Grace at Fulton County.
Yes, ma'am.
Will do, Ms. Grace.
Okay. She'll come and get you if you don't.
And I'm sorry, add-on calendar,
Oh, yes.
be reset further notice
Gotcha.
to be released to DeKalb County amended bond order 4,000 SOB.
Amended to 1,000?
No, 4,000.
4,000, right, 4,000. Okay. That's all I have. Mr. Howard, is he around or who's doing that calendar today?
He, I believe, should be on. I'm not sure when. I'll try and give him a call once I leave the court.
Okay, appreciate it. Thank you.
Thank you, Your Honor.
All right, thank you.
Hey, Judge,
Yes.
on the competency calendar, position 12 and 13, the parents are here. I think Ms. Lewis gave them the Zoom link. Let me verify that with her. I'll be
Okay.
right back.
Okay.
I'm talking to she hear them say.
Judge Missy, will someone be contacting Mr. Howard to see if he's gonna log on? Or who's gonna do the competency calendar? I was just informed that he's on vacation, so who's gonna do the competency calendar?
He's doing it, and I've contacted him via text,
Okay,
and we spoke earlier today, so.
He's logging on. Mr. Howard is.
He's logging on. I just spoke to him. He should be on.
Oh.
Your Honor. Anybody?
They are in the breakout room for the composite calendar. What defendant is this?
Position 7, Mr. Peters.
On the composite calendar?
Yes.
Okay. All right, thank you. I'll let them know.
All right.
Hello, is anyone from the jail on?
Yes.
Mr. Howard says he need Joshua Stout from the Compassy calendar. Will you guys be bringing him?
Maybe courtroom 2. I'm on 3 North with Peters. Someone else had to get Stout.
Okay. Courtroom 2, are you there?
Go for courtroom 2.
Hi, do you guys know if you will be bringing out Joshua Stout from the Compassy calendar? Mr. Howard states that he needs Mr. Stout.
But Mr. Howard also stated this morning he only needed one person for the time. So I didn't know anything about Mr. Stout. I asked him that before I left the courtroom this morning.
Okay, so I let him know that he's not available then. Okay, thank you.
They're still here, Your Honor. The family's still here, Your
Oh,
Honor.
they're still here. Okay, good. You're muted. Derek.
I see courtroom 2 on the screen. Can someone unmute in courtroom 2?
Yeah, I think Ms. Champion is my Zoom master. But Miss Grace is doing good too. Courtroom 2. Courtroom 2.
I don't know. I don't know, Judge.
Hey, Your Honor.
Hi. You all have Mr. Stroud?
We wasn't told to get Mr. Stout.
Mr. Howard said.
Deputy
Howard,
Norris.
hey, Howard, did you tell me to get Stout?
I didn't tell you to get this out. I did call back and tell Deputy, and he said, okay, he would get him.
Okay, so he's en route then, because I don't know. Yeah. I was doing misdemeanor.
He's on two south. Is there any way we can find out? Any way you can radio Deputy to make sure he's on the way or something? Because we got the family on. We're trying to we need Mr. Stout on so the judge can instruct him.
Give me a second. Let me try to get in contact with Officer Duffy real quick.
Right.
All right. Hey, Mr. Howard.
I don't know what.
Yes, thank
This
you,
is-
Deputy Norris.
This is Mr. Stout, but
Thank
just in the future, Howard.
Yeah,
when you
yeah,
ask these people, you
yeah.
gotta
I
make
should've
sure you
told
have it,
you.
because you know it runs into our other calendar.
Yeah, I was gonna, he was somebody I should have told you about first thing. But I ended up, yeah, I apologize for not telling
All
you.
right. Here's Mr. Stout.
All right.
Good afternoon, Mr. Stout.
Can you
Can
see
you
it?
hear us, Mr. Stout?
That's always been.
Oh, I don't,
My family, and that's anybody in my family.
Mr. Stout? Hey, deputy. Oh,
Okay.
I think you can now.
She was screaming at me.
Can you see us, Mr. Stout? And you can hear us okay? I know it may be, you can?
I don't, my dad kept my mom.
Okay. Go ahead, Derek. I'll let you start since he,
Okay, Mr. Stout, you remember you and I met and we discussed that we were going to be working on a plan to get you released. And you also met with Miss Amin Williams, our social worker, who's on the call as well. And I've spoken with your family and speaking with you. We're going to ask that you be released to your mother, who's here on the line on the Zoom call, so that you can be taken to Ridgeview to follow up with your treatment there. When you and I met, you had indicated that you believe that's what was best. That was what your mother was wanting you to do, and you were okay with that. And so the judge is agreeing to release you to your mother so that you can be taken to Ridgeview. And then you'll follow up with your mental health treatment there. And just, you'll need to comply with whatever conditions that and treatment that they recommend so that we can, continue to move forward. All right, so that's going to be the plan. The judge will talk with you more about what's required.
okay?
You okay with that, Mr. Stout?
Sure, because you're the one who's investigating.
Well, we want to make sure that you do it. I think it's going to be the best for you. But I'm ordering you to go to Ridgeview, Riverwood rather, and want to make sure that you go to Riverwood. Would you do
And I think
that
it
if
is
I ordered you to do that? Ridgeview. I
Yeah,
might
it
have
is
said
Ridgeview and Smyrna, yes.
Ridgeview and Smyrna. Okay. So will you go to Ridgeview to get some treatment for me?
How long will I be there?
That's where I stay. That's where I stay, literally.
Deputies. How long would you stay there? I'm not sure. That will be determined by the doctors.
Keep me out my own house.
I don't want to give a number or a time and then it sticks in your head because I'm not the doctor. I'm the judge that's ordering you to go.
Y'all got a place for me to go?
Hey, hold it down so we got four.
I'm ordering you to go there for treatment and to follow their plan, whatever they come up with after they evaluate you. Okay, because I can't tell the doctors exactly what to do. But once they assess you and you go there, you'll have they're going to take you the same day, I believe. And so get you there as soon as we can. And then they will evaluate you to determine how many days you'll need. But I just wanted you to promise me you'll cooperate and do that so that we can get you the help that you need. And then you can be better and everything can work out with your family. You have a lot of support and they care about you a lot. And they are definitely here to help you. You see them on the line. I don't know if they're still on. Can you turn on your cameras, family?
I didn't do none of those things.
There goes a familiar face there. Unmute yourself.
Hello, Joshua. We're here for you, okay? And we love you very much.
Okay.
No, I do not.
All right. They're here for you. So when you're released to them, they will take you right to Ridgeview, and you can cooperate with that and get the assistance that you need there. Okay.
That's kind of right for them to know all the way.
She's not trying to move nowhere. She don't have nowhere to go.
Excuse me, Deputy, I'm sorry, Judge, please forgive me. Deputies in courtroom 2.
Yes.
We-
It's
we-
not the
we're here-
deputy, we got somebody interviewing for misdemeanor first appearance.